1-4.
Yes.
That was your lordship's order. During that time, though I was not named in the FIR, I was during that time working as a junior assistant. Now I have been, after departmental proceeding, my lord, I have been dismissed from service. And now, my lord, notice under 35 has been issued to me to appear. I want to appear, my lord. And during that time, my lord, I think, my lord, this is the dismissal order. I'm giving I am not in service nowadays. I have been dismissed from service, and now, my lord, 35 notice has been issued. Your lordship will find at page 27 last. I want to appear and give my statement, my lord. 27, my lord, last. Your lordship will find 35 notice. And now I am not in service, I am dismissed, my lord. Your lordship, last time when your lordship rejected, said that I may tamper with the evidence and the documents was with me. Page 22 and 27 are the 35 notice that been issued. I have taken time, I want to appear and give all my...
Oh, when the earlier application was dismissed by this court?
My lord.
When?
It was page 14, my lord, 1-4.
21-25.
Okay.
Now 35 notice has been issued now.
My paper only after the case diary is figured out because Shorty was present the case diary and then the case the early rejection.
My lord, I will just appear, and my lord, because notice has been issued, I will go and place my statement. I am not in service also, my lord.
Where
Page-
this court has observed that if the privilege of previous bail is granted to you, then you will tamper the evidence.
Because, my lord, maybe your lordship that
Is there any observation in the order?
my lord, only during that time, my lord, your lordship will find one observation at para 5, your lordship has said. On the other hand, by producing the case diary before this court, Mr. Sharma learned additional purpose submit if accused is enlarged on bail at this stage that he may destroy the evidence of TI book and fee book of the office of the sub-register, which he kept in some other reliable person. That was the observation. That may be the submission.
That was the submission, not
Submission.
observation of this court.
My lord, at page 16, para 7, the case diary indicates the IO has collected sufficient incriminating material in support of the allegation made in the affair. It further appears the investigation is still going on and some important document yet to be recovered and seized.
Yes. Where is the observation of this court?
Now, that much is there, my lord. And
Okay, let the city come.
my lord, can I go and appear on the next day, my lord, if your lordship give me some?
There is no bar.
Well, otherwise he may be arrested, then this will become infectious. I am not in service, my lord. I have given the dismissal order also, my lord. And the notice has been issued to
Your
me.
remaining in service or not remaining in service does not matter in dealing with this petition.
My lord, because maybe during that time, my lord, your lordship thought of that I was in office. I may have tampered the evidences, but now I am not there. I have been thrown out, my lord.
Let the city come. Heard Mr. Roy Chaudhary, learned counsel for the applicant. And also heard Mr. Goswami, learned additional PP for the state respondent. This application under section 482 of the BNSS 2023 is preferred by the applicant for grant of PRS bail, who has been apprehending arrest in connection with Hatigao PS case number 254 of 2024 under section 120B 406 420 468 IPC. Mr. Roy Chaudhary, learned counsel for the applicant, submits that this is the
Page 27.
second application.
Second application.
Second anticipatory bail application preferred by the applicant. And the first one was dismissed by this court by the order dated 28/1/2025. The learned additional PP submits that to dispose of the present petition, perusal of the case diary is found to be necessary, and he submits that the case diary may be called for. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that Mr. Goswami learned that additional PP shall produce the case diary before this court on 5th of March. Sorted.
If your lordship, with bowing down my head, not to take any coercive action.
No, no, sorry. Earlier it was rejected.
My lord, this matter may be taken up after some time, my lord. My senior is on legs.
I may start because we have finally everything. It's in your account.
Pardon?
Madam, I may start, my lord, because we have finally everything.
Who has the right to start?
If you're also pardons, my lord.
Sorry.
Publish.
May I please, Your Lord?
Yes.
Here is the case, my lord. The petitioner at first has filed a suit, my lord.
Caveat, yes. You file, madam, you file caveat. Caveat or VR, caveat. Yes.
So the petitioner herein, my lord, at first filed a suit in the court of civil judge senior division, my lord, at TS number 13/24. Then, my lord, during pendency of the suit, the defendant number 1 and 2 has filed WS and counterclaim. Meanwhile, that defendant has also filed a petition under section 144 CRPC. Now, the order of initiation of that CRPC, my lord, that the present petitioner has filed an appeal before the session judge against the order of notice. Then the session judge, after hearing the parties, has allowed the appeal, my lord, that appeal, and dismissed that petition under section 144 CRPC, my lord. In the meantime, my lord, the engaged advocate of that criminal proceeding, that 144 CRPC, my lord, the engaged advocate has filed a suit, my lord, against this, my lord, the suit which is involved in the first suit, my lord. The suit is involved in the first suit against that property, my lord. The respondent number 1 and 2 of the present case, who was earlier advocate of the defendant of 1 and 2, and present respondent number 3 and 4, before the same court, my lord, which was registered as 63/24.
Mr. Sinha.
Yes, my lord.
This order dated 17/12/2025 is the impugned order,
Yes, my lord.
right?
Yes. So here, my lord, that suit was decreed, my lord. The filed by the respondent number 1 and 2, that suit 63/64 was decreed. So, my lord, on admission of the defendant, respondent number 3 and 4, that they have sold the suit land to him, and for specific performance of the contract, my lord, the suit was filed to complete the sale, my lord. Now, that suit was dictated, the present petitioner did not know, without making the parties, though they know that they have appeared in the earlier suit as the defendant and also engaged advocate, my lord. So now, in this case, the petitioner has filed an application under that Rule 97, 98, 101, so and so of. So, my lord, that the execution proceeding was stayed, my lord. And so it is a suit, my lord. It is a suit of the claim of the present applicant, my lord, present petitioner, my lord. So it was proceeded, and the affidavit evidence for the side of the petitioners have been submitted also. Then date was fixed for cross-examination. And cross-examination, in the meantime, the present petitioner found the advocate of their advocate is not suitable, my lord, and suit was dismissed. that miscase number 232/24 was dismissed. So 232/24 is a kind of suit in the execution proceeding. As per that, my lord, 97, rule 97. The thing is that, in the present, this petition under 227, Article 227, here that application which we have filed is not annexed, my lord. Very petition of 232 is not annexed, my lord. So, my lord, if your lordship allows me to file that one, my lord, by way of additional affidavit, my lord, the main petition of where this order has been passed and evidence has been taken on respect of the petitioners, my lord.
That is not part of the record.
It's not part of the record, my lord. It's a miss, my lord, that application has not been filed, the 232 petition. If your lordship allows me, then I will file additional affidavit.
Interim decree was executed.
Executed.
Yes, decree executed, my lord.
Petition under order 97 is a decree, my lord. Appeal license, my lord.
Order pass under?
Order 21 June 97, their application was filed under order 21 June 97. That petition was rejected, my lord. Therefore, appeal license.
Oh, why it is rejected? Yes. Why it is rejected, my lord? Because they changed the advocate and they could not, my lord, cross-examine the witness. That the witness did not appear.
Petition has become into the already.
Order 41 rule?
Order 21.
Order 21 rule 97. It is a suit, my lord.
So the order amounts to a decree.
Decree, my lord.
So against the decree, only appeal will.
Like-
Appeal license.
So you file appropriate petition then. Withdraw this petition if not maintainable.
My lord, that order, whether it is, my lord, is a order of actually dismissed for default.
It was dismissed.
No, it was dismissed for default. Actually, it was dismissed for default, not the final order. Your lordship will find page 153, 17, annexure 17. That will make clear, my lord. Annexure 17, page 153. May I read, my lord? The petitioner side is absent today without step. That is we, my lord. The decree holder, opposite party, and judgment debtor, opposite party has been represented by their engaged counsel. The engaged counsel for the petitioner side is directed to ensure the attendance of all the PWs at 10:30 a.m. sharp on next date, fixed to face cross-examination. The witnesses are to be cross-examined on my behalf without fail. And in the event of non-compliance, the case will be dismissed for default. Let this order be shown to the learned advocate of the petitioner side for compliance. Then on next day, my lord, they have found that advocate is not suitable, so they have filed again petition for adjournment, my lord. So then, my lord, that court.
No, Mr. Sinha,
Yes, my lord.
this is not the impugn order.
No, 17, 12, 25 is the impugn order.
17, 12, 20.
Yes, this is the impugn order.
Then
This is the impugn order. So earlier to that order, that if witnesses are not to be examined, if not examined, then the petition will be dismissed for default. But here the case that the honorable court, learned court, my lord, while making dismiss for default, he has dismissed the suit, that petition. He has already meant earlier. Earlier already meant that if witnesses are not examined, then petition will be dismissed for default on the earlier occasion. So these are connected, my lord.
no, that is not the impugn order. Impugn order is 17, 12, 20.
No, 17, 12 has come up, my lord. That's true. 17, 12, 17,
So
12,
that,
12 defined.
No, Mr. Sinha, you say, the application was dismissed. So that is a final order that amounts to decree.
My lord,
So.
yes, I agree with your lordship, my lord, whatever lordship say. But this 1712 order has come up, it is connected with the earlier order.
Maybe.
The date is fixed for
maybe.
examination, cross-examination of the witness.
Okay, you filed that application, which you have not enclosed with this petition.
Yes, my lord,
And
let me
in
file.
the
My lord.
meantime, we will also hear on the point of maintainability.
Okay, my lord. Okay.
Heard Mr. B. Sinha, learned counsel for the petitioner, and Ms. S. Miller, learned counsel for the respondent. Mr. Sinha submits that the application filed before the learned executing court, on which date you have filed that application?
My lord, there is a date. Because on the application itself is there, my lord. I have not mentioned here. So that's why I will file, my lord. Now, when the notice has been issued in respect of this execution proceeding, then he have filed this miscellaneous petition 232. It is in that
File
petition. so I
one
don't have it.
petition, the petition based on which Miss case number 232 of 2024 has been registered is not enclosed with this petition. And he submits that he may be granted some time to bring on record the said application by filing an affidavit. Fair allowed. However, Mr. Roy, learned counsel for the respondent, submits that the civil revision petition is not maintainable in view of the fact that the order passed by the learned executing court amounts to a decree against which only appeal will lie. Under in view of the submission of Ms. Roy, learned counsel for the respondent, Mr. Sinha, learned counsel for the petitioner, has to satisfy this court on next that regarding maintainability of this civil revision petition. List on.
27.
Always.
Item 5.
May it please your lordship. This is minor, there is a transfer matter from DC just Sipsago to family court Kamrup Metro. There is a mistake, my lord, I have to mention it. District Sipsago, instead of that, there is a written as Tinsukia.
Yeah. Pardon me, sir, your name please?
NC Das.
NC Das, learned counsel for the petitioner. Mr. Das submits that some mistake has crept in the cause title of the petition.
What's title petition and some of the portion in the
Pair.
prayer.
The pair and cause title and pair portion of the petition, some mistake has been crept in, and
The prayer is correct, my lord. Prayer is correct. Some of the paragraphs in the middle
some
of the
paragraph
petition.
in the petition. Some mistake has been crept in, and he prays for granting him some time to file interlocutory application for amendment of the application. Pair allowed, recessal is the matter of time. 1 week,
My lord, Monday,
next
Next.
Monday.
next Monday.
23rd.
23rd. March.
Item 6.
This revision petition has been filed challenging an order passed by the additional session judge in miscellaneous appeal, my lord. Against an order passed under Order 39 Rule 1 and 2 granting injunction in favor of the plaintiff's petitioner herein, my lord. The learned trial court had, my lord, passed an order, my lord, page number 57 on 10/5/24.
So you are for the plaintiff.
I am for the plaintiff, my lord.
So trial court has granted
Granted
injunction in your
injunction
favor.
in favor of the, my lord, page number 64 is the operating
Thereafter,
part.
the defendants have filed
filed an appeal, my lord,
appeal against that order.
against that order. And what
And
happened, my lord?
in
This-
the appeal, the order was set aside, however, it is directed to maintain status quo.
Status quo. But my lord, what happened, my lord? During pendency of the appeal, my lord, I have annexed an FIR, my lord, kindly page number 83. They have, my lord, tried to dispossess us, my lord, by taking away the betel nut from our garden, my lord. And we had informed the police, my lord. They have so muscle power that they have attacked the police force, my lord, page number 483. Kindly, my lord, pending the appeal, my lord. They have attacked the police force. They have damaged the police vehicle, my lord, and the page number 83, my lord. Kindly, the FIR lodged by the police, my lord. During pendency of the appeal, my lord, they are so muscle power and they have both the muscle power and the financial power, my lord. And the petitioner herein is the only son and his my lord. And on the other hand, the defendants are the paternal cousin, own brothers, and the my lord, the nephews and the grandsons of the original predecessors. So more than 15 or 20 persons are there, my lord. So what happened, my lord, during the pendency of the appeal, where the status quo not, my lord, passed, at that time they have, my lord, attacked the to dispossess the petitioners, my lord. Kindly,
No, here 26/11/2025 is the impugned order.
yes, my lord. Kindly peruse, my lord, the FIR first, my lord, page number 83, my lord. It
So
will,
let the notice go at this assess.
my lord, kindly for a moment, the FIR may be perused, my lord. The conduct of the defendants,
We will hear you. Let the other side appear.
my lord, the conducts of the to be, my lord, kindly
No,
consider, my
on
lord.
the conduct of the appellant, we will not pass any order, no?
My lord, in such a situation, my lord, they have got a status quo, my lord, and by their muscle power, my lord, any moment they are, my lord, ready to, my lord, take the possession, my lord. Because, my lord, the appellate
No,
court only,
status quo order is already there.
but, my lord, in the status quo order, kindly, my lord, peruse page number 101, my lord. The appellate court held that they have the possession, my lord.
Oh.
The appellate court held, my lord. The defendant have the possession, my lord. This is the problem, my lord. How the appellate court held that they have the possession, my lord. And another aspect is there, my lord. Kindly peruse the order of 9/1/25. Before passing the status quo order, the honorable court had ordered a, my lord, inspection, physical inspection and report by the LR staff, my lord. And without the LR staff reported that, my lord, plaintiff has the possession, my lord. It is on record, my lord. The LR staff reported that the plaintiff has the possession. It is on record, my lord. But without taking consideration of the report, my lord, called for by the appellate court, my lord, the order is passed, my lord, declaring that the defendant has the possession, my lord.
No, now we were not in the position.
We are in possession, my lord.
Now.
Now, my lord. But the honorable appellate court held that they are in possession, my lord. My lord, kindly peruse the order of the honorable appellate court, my lord, where the inspection was ordered, my lord. 9/1/25, page number 76, my lord.
No, that is not the impugned order here.
No, my lord. This, the honorable appellate court to ascertain the possession, my lord. Page number, my lord, the page number 76, my lord. To ascertain the position, my lord, ordered for inspection, page number 76, my lord. There was a specific order, my lord, by page number 76, honorable apex court held, my lord, that by petition number so and so, prayer for issuing commission for giving full report about location and dispute and land between the parties, my lord. The rough sketch up submitted by the parties, both the parties submitted, my lord, reflect that the DAG number so and so 1996 respectively, perhaps this is crux of the dispute between the parties. If the location of the particular plot of land can be identified, the court will be positioned. Now, my lord, 1A, the precise location of the lands mentioned in Schedule 1, Schedule 2, and Schedule 3. B, my lord, page number 77. These are what is, my lord, the honorable session court asked for, my lord. The possession, B is the possession of the respective parties. This is important, my lord. Now, my lord, that I have annexed the report, my lord. Report is, my lord, page number 78. Kindly, my lord, page number 78. This is a report of the circle officer, my lord. After the conduct of inspection, my lord. My lord, point number B, my lord. Page number 78, point 1B. House owned land for vegetables cultivation which falls under pattern number so and so, possessed by Sirajuddin is the petitioner, my lord. Sirajuddin, son of so and so Hasmat Ali, a part of land under so adjacent to the western boundary, betel nut trees and some other vegetables are noticed, which also under possession of the Sirajuddin, the petitioner. This report, my lord, is not considered, my lord, in the impugned order. Without considering this report called by the same court, my lord, the Honorable Appellate Court held that the defendant has the possession, my lord. Kindly page number 101, my lord. 101, my lord. There is the impugned order, my lord. Without consider, there is no mention of this report, my lord, in the impugned order, whole impugned order. Page number 101, my lord. Paragraph number 16, my lord. Learned trial court has stated that as there exists dispute necessary to adjudicate it, therefore prima facie case in favor of the plaintiff respondent. However, having a dispute requiring adjudication means there is a cause of action which different from the prima facie case. The defendants have land on eastern side of the E&D band and is not disputed by the plaintiff. However, the learned trial court has expressed uncertainty on the point whether the land of the opposite parties remain on the western side of the E&D band. Therefore, it is not clear that the balance of convenience lies in favor of the plaintiffs. Moreover, learned trial court failed to demonstrate as to how the plaintiff respondents will suffer irreparable loss. So for this, the Honorable Appellate Court held that the an inspection report is required, my lord. And after inspection report is found that the possession is of the petitioners. Now, my lord, paragraph number, my lord, next paragraph. From the above discussion, this court has arrived finding that learned trial has not properly appreciated the golden principles 18 from the facts and circumstances which has come into the case and mentioned hand above. This court is of considered view that the learned court failed to exercise discretion so and so. However, as the title suit is pending, final adjudication order preserve the suit land. This court deems it proper to direct the status quo, my lord. Now, my lord, in acknowledgement the mother and the yes, and so, my lord, this report has not been considered by the my lord, the learned appellate court, my lord, session court, and my lord declared that they have the possession and to direct to maintain the status quo. The only, my lord, point is that if this is, my lord, is not interfered with, at any moment they are, my lord.
Oh, where is the observation of the appellate court that you are in position? No, sorry, the defendants are in position.
Yes, my lord.
Where?
My lord, page number 97, my lord. Page number 97, 7.2, my lord. That as the appellants are in physical possession, page number 97, my lord. That the appellants are in physical possession and occupation over the part of the parcel of the suit land, whereupon injunction is passed and thereby restrain the right of use of the occupation of the appellants over the suit land.
No,
Is-
no, that is not the observation.
Yes.
Is it the observation of the court?
Yes, my lord. Regarding the possession, my lord, the Honorable Appellate Court, my lord,
No,
the
no, that
this
is the plea of the,
yes, my lord, yes.
that is the pleaded case of the appellate.
Yes, my lord.
before
This
the-
is, my lord, the Honorable Appellate Court, my lord, taken into consideration that they are in possession, my lord.
No, no, no such observation was made by the appellate court.
Well, Appellate Court, my lord, regarding
Where? In the impugned order where the appellate court has observed it.
the Appellate Court, my lord, specifically not mentioned, but
Then,
Appellate Court, my lord, held that the trial court could not come into finding that the petitioners are in possession. That
No,
is the, my lord,
if,
finding, my lord.
no, Mr. Kadir, you say
Yes, sir.
the appellate court has directed to maintain status quo.
Yes, my lord.
And now you are in position of the suit land.
Yes, my lord.
Then
No, appellate court did not held that we are in possession, my lord. Appellate court held that a trial court could not decide who are in possession, my lord.
There is
That
no
is, my
such
lord.
finding.
That is paragraph number 16, my lord. Page number 102, 16. That the trial court could not come into the conclusion that who are in possession. 102, my lord.
Mm,
102.
mm.
Page number 102, paragraph number 16. Learned trial court has stated that as there exists a dispute necessary to be adjudicated, therefore prima facie case in favor of the plaintiff. However, having a dispute regarding adjudication means there is a cause of action which the different in prima facie case. The defendants have land on eastern side of the band is not in disputed by plaintiff. However, learned trial court has expressed uncertainty on the point whether the land of the opposite parties remain on the western side of the END band. Therefore, it is not clear that the balance of convenience lies in favor of the plaintiffs. It is the observation. But, my lord, to ascertain this, my lord, the learned appellate court issued for an inspection, my lord. Only for this ascertainment who are in possession, my lord. And this is, my lord, pending appeal, my lord. And the appellate court, the report of the LR staff and the circle officer that we are in possession.
Okay, let notice go ahead. This is this.
My lord, if the order is not stayed, my lord, at this point, my lord, till the returnable date, my lord, at any moment, my lord, they are able to attack the police force, my lord. Page number 83, kindly for
Learned counsel for the petition. This petition under Article 227 of the Constitution of India, they do it. Article 151 of the Code of Civil Procedure, related to Section 151 of the Code of Civil Procedure. The petitioner has challenged the judgment and order dated 26/11/2025 passed by the learned additional district judge Hailakandi in Miss Appeal number 6 of 2024, whereby the order dated 10/5/2024 passed by the learned civil judge senior division Hailakandi passed in Miss J case number 225 Proc 2023 arising out of title suit number 129 of 2023 was set aside. Peruse the petition and the documents plus on record. Also peruse the impugned order, judgment and order dated 26/11/2025. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Mr. Kadir, learned counsel for the petitioner, submits that the petitioners are in possession of the suit land, and in their favor, the learned trial court has granted injunction. But in appeal, the learned appellate court has set aside the same by holding that the prima facie case, balance of convenience, and irreparable loss are in favor of the respondent hearing and granted status quo, and referring to the inspection report submitted by the circle officer, which is enclosed with this petition at page number
78, my lord.
78 of the petition. Mr. Kadir, learned counsel for the petitioner, submits that there is a clear finding of the circle officer that the present petitioner are in possession of the suit land, and in spite of the report of the circle officer, which was flashed before the learned appellate court, the learned appellate court has illegally found the prima facie case, balance of convenience, and the irreparable loss in favor of the respondent herein and granted status quo, and the said order dated 26/11/2025 required to be stayed till returnable date. Having heard the submission of Mr. Kadir, learned counsel for the petitioner, I have carefully gone to the report dated 27 January 2025 which is annexed with the petition as annexure number 9 at page number 78. And also the finding recorded by the learned appellate court in the impugned order dated 26/11, judgment and order dated 26/11/2025. And this court finds sufficient force in the submission of Mr. Kadir, learned counsel for the petitioner, and accordingly, taking note of his submission, especially taking note of the report furnished by the circle officer, which is annexed with the petition as annexure number 9 at page number 78. This court is of the view that the impugned order dated 26/11/2025 is required to state till returnable date. Accordingly, the impugned order dated for instance state till returnable date list after 4 weeks.
Highly obliged.
May it please, Your Honor. Your Honor, criminal revision petition, Your Honor, filed under Article 227, Section 115 and 151 of CPC, Your Honor. Your Honor, we have challenged the interlocutory order dated 3/11/2025 passed in money execution number 6 of 24 by the civil judge, Senior Division, Sonipur at Tezpur. Which is passed in a petition number 490 of 2025 dated 16/7/2025. Lordship, this petition number 490 of 2025 is on page number 47, Lordship. Lordship, kindly come to page number 47. Lordship, this is the petition filed by the decree holder, Lordship, for attachment of movable properties of judgment debtor under Order 21, Rule 43. Here, Lordship, in page number 48, Lordship, they have mentioned the schedule, Lordship. That is vehicle, two-wheeler, and a car, Lordship. But in A, Lordship, the registration number is not clear. And Lordship, in in 2, Lordship, they have mentioned that furniture, almirah, home appliances, TV set, and etc. So, Lordship, this word etc. Lordship, as used in the aforesaid petition by the decree holder, includes beyond the movable properties of the JDs, and accordingly, the said petition suffers from devoid of merits alone. Over and above, the word etc. means so on, inclusive of every household standing inside the house of the JDs. So, in that sense, it includes treatment of the third party, which is the wives of the JD appellant, Lordship. So, Lordship, and also this petition is entertained by the Civil Judge Senior Division, Sonipur, Lordship. This petition, they have not given here any verification and affidavit, Lordship. Lordship, vague and unidentified schedule without verification or affidavit is nothing but a abuse process of law, Lordship. Then, Lordship, against this petition, we have filed our objection on 16/9/2025. That is in page number 49. Then, Lordship, on 3/11/2025, Lordship, the learned trial court has passed the order by allowing this is a attachment petition of the decree holder, that is the sole respondent, but they rejected the averments of our objection, which we have filed, Lordship. And in page number 57, in discussion, Lordship, the court has the view that the judgment debtors have claimed that the items listed in the schedule, such as furniture, almirah, home appliances, and vehicle, includes freedom of his wife. However, no material document or has been produced to substitute
The decree?
But Lordship, this petition entertained by the learned civil judge, Senior Division, Lordship, is suffering from material irregularity, Lordship.
How?
Lordship, verification is missing, affidavit is missing, schedule is not clear, Lordship. And they have used the word etc.
The case you have referred here,
Yes, Lordship.
Procedural, there Supreme Court has directed that the decree has to be executed within 6 months.
But Lordship,
Court is not bound to execute the same
yes, Lordship.
within the stipulated
But
period.
But
Picked
she
by
didn't
the
find
highest
Your
court?
Lordship, the proceeding itself suffering from irregularity, Lordship.
Okay, if today is the date fixed,
Yes,
if a
Lordship.
writ has already been issued,
Yes, Lordship.
you obtain up-to-date status of the case, we will take it up at 2 o'clock.
At 2, Lordship. Obliged.
May it please your lordship. My lord, impugn order, your lordship will find from page 141. Starts from page 142. And the operative part, your lordship will kindly take up page 144 from paragraph number 8 onwards, my lord, if I may read. Paragraph 8, page 144. May I read this two paragraphs, my lord? Case record reveals that the statement made by the petitioner, respondent number 3, is sustainable, and the petitioner, respondent number 3, had immediately taken steps after the appeal proceeded ex parte against him. It would not be out of place to quote the observation made by the Honorable Supreme Court regarding the definition of sufficient cause as enshrined in Order 41, Rule 17(2), read with Section 151 of the CPC. Sufficient cause is understood as a legally adequate reason and persuades courts to exercise discretion in favor of condoning delays for setting aside dismissal. It must be such that it convincingly justifies the delay or non-compliance, often requiring the reasons to be deemed adequate and reasonable by the court. Then, my lord, there is a citation quoted, Union of India versus Manager, Jain and Associates, Supreme Court. And then Dhiraj Tiwari versus Ministry of Environment, Forest and Climate Change of National Green Tribunal. Court emphasizes that sufficient cause should be compelling enough to persuade judicial discretion, often involving factors like improper service, unavoidable circumstances, or genuine inability to appear. Union of India versus Manager, Jain and Associates, Supreme Court. P.R. Saravanan versus K. Dhanalakshmi, died K. Shivakumar, Madras. The petitioner, respondent number 3, is not found to have caused any inordinate delay in appearing in the appeal hearing. Hence, in the light of the observations made by the Supreme Court Supra, the cause cited by the petitioner, respondent number 3, being considered as sufficient, petition number 209825 stands, allowed with the cost of 2,000 to be paid to the other side as the cost of litigation. Accordingly, ex parte order dated 24/9/2025 stands vacated. My lord, I am aggrieved by this order on 3 counts. First, my lord, the petition that was filed was not at all maintainable. My lord will kindly take up the provisions of Order 41, Rule 17(2) for a while. And we had filed objection. We had taken this stand specifically against the petition. Your lordship kindly takes up Order 41, Rule 17, Sub-Rule 2, CPC.
Order 41.
Order
rule.
41, Rule 17, Sub-Rule 2. That is the provision under which they had filed the petition before the learned appellate court for vacating of the ex parte order. Now, what does it say, my lord? Order 41, Rule 17(2). 17 is dismissal of appeal for appellant's default. 17(2) is hearing appeal ex parte. Where the appellant appears and the respondent does not appear, the appeal shall be heard ex parte. Now, this is the provision under which they filed the petition praying for vacating of the ex parte order that was passed against respondent number 3. Respondent number 3, on the date on which he was supposed to appear after receiving of notice, did not appear. The learned appellate court below, in its previous order, categorically came to the conclusion that after due service of notice, the respondent number 3 did not appear, hence due ex parte proceeding of the appeal. Now, to vacate that order, they came before the same learned appellate court below under the provisions of Order 41, Rule 17(2), which does not facilitate the learned appellate court to vacate the ex parte order. Procedurally, my lord, the provision under which the petition was filed, that provision is
Okay, let
that
knowledge
is-
go at this.
My lord, one more thing, my lord. In so far as the participation of this respondent number 3 in the appeal proceeding is concerned, that is vitiated by the fact that in the suit he was not the plaintiff. He was the principal defendant number 1. During the suit proceeding, he filed a petition under Order 12, Rule 6, admitting the claim of the plaintiffs without there being consent from defendant number 2, who is the petitioner here and the appellant in the main appeal. We pleaded collusion between the parties, and eventually the learned court below, I have annexed that order, rejected the petition under Order 12, Rule 6 of respondent number 3, but transposed him from being defendant number 1 to being plaintiff number 3. Thereafter, during the suit proceeding, he neither amended his written statement, nor did he come up with any pleadings of his own. He did not even participate by.
Okay,
So,
all right.
My lord, my prayer at this stage, the appeal has been filed by me. Your lordship issues notice. Let this aspect be examined by this honorable court. My appeal may be, the proceeding of my appeal may be stayed till the returnable date. My lord. Let them come and respond. I'm praying for stay of the proceeding of my appeal. My lord.
Heard Mr. D. Chakraborty, Lorded Counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 3/2/2026 passed by the learned civil judge, Senior Division, Lakhimpur, North Lakhimpur, in petition number 2098 of 2025, arising out of title appeal number 10 of 2025. It is to be noted here that by the impugn order dated so and so, the learned appellate court in the petition under Order 41, Rule 17(2), read with Section 151, CPC filed by the respondent number 3 has been allowed. Mr. Chakraborty, learned counsel for the petitioner, submits that under the Order 41, Rule 17(2), CPC, the appellate court has no power to vacate the ex-parte order
Right.
dated 24/9/2025. And that there is a collision between the respondent number
3 as
petitioner
with
respondent
respondent number 1 and 2.
with the
respondent number 1 and 2.
with the respondent number 1 and 2. Then under such circumstances, Mr. Chakraborty submits that at this instance, notice may be issued to the respondents and title appeal, further proceeding of the title appeal number 10 of 2025 filed by the present petitioner may be stayed. Having heard the submission of Mr. Chakraborty, learned counsel for the petitioner, this court has carefully gone through the petition and the documents placed on record and also perused the impugn order dated 3/2/2025. Let notice be issued to the respondents, returnable in 4 weeks. Step by speed post, also by usual process within a week from today. And pending further consideration, further proceeding of title appeal number 10 of 2025 is stayed till returnable date.
Highly obliged.
List of 4 weeks.
Deeply obliged.
Orders. As number 17.
May I please, your lord. My lord, kindly peruse the office note dated, my lord, 13/2/2026. LCR of title appeal number, my lord, has not been received by the section. And my lord,
Okay,
Twin-
let the reminder go
my lord,
to the
and my lord,
appellate court.
my lord,
Heard Mr. T.U. Laskor, learned counsel for the appellant, and Mr.
On behalf of L.R. Mazumdar.
Learned counsel appearing on behalf of Mr. L.R. Mazumdar, learned counsel for the respondent number 1. Office note dated 13/2/2026 indicates that LCR of TS number 84 of 2009 has been received, but TA number 34 of 2016 has not yet been received. Accordingly, it is provided that Registrar shall issue urgent reminder to the learned appellate court for transmitting the record of TA number 34 of 2016 to this court. To this court, list the matter after 2 weeks.
My lord, one thing, my lord, I have filed, my lord, already, my lord, that has been disposed of, IA 3167. 3167 disposed of for substitution of the legal heirs of the sole appellant, my lord. That cause title has been, my lord, filed, that is marked as X, my lord, before your lordship. Cause title.
Filed.
Yes, my lord, that is marked as X, my lord.
Okay, all right. Is it necessary to pass any order on this point?
Not. Fine.
Okay.
Obliged.
Yeah, please. Despite several states lawsuit, nobody has appeared lawsuit for the opposite party.
You want to take fresh step? You want to take fresh step?
I will take it. Okay.
Heard, mister, your name please?
R. Hopler.
Learned counsel for the petitioner. Office note dated 23rd 5 2025 indicates that neither ethic card nor answer notice issued to the respondent returned till date. The learned counsel for the petitioner submits that he will take fresh step. Accordingly, it is provided that step be taken by speed post and also by usual process within a week from today. List the matter after 4 weeks.
Interim order may be
Interim
continued.
order pass order shall continue.
Obliged.
Item 19.
My lord.
Yes.
No, this is an application plot. The landlord-tenant case, my lord. What happened? Oh,
Service completed?
service is what happened. This the respondent, he left the place. Left the place after selling out. This is a landlord-tenant. We are tenant. During the continuation of the tenancy, the tenanted premises was demolished, and we were forcefully evicted during the continuation of the proceeding. Then we have filed an application before the lower court for restoration of the possession. That application was allowed. That application was allowed. Against that order, the landlord has preferred a revision application before this court, which was dismissed. Now, what happened? Why we are before this honorable court? That meanwhile, my lord.
Oh, Mr. Doctor, service is yet to be completed. We cannot hear the matter.
There is subsequent facts.
No, there is subsequent fact. Therefore, my lord, I'm taken indulgence to submit. After filing of this revision application, then the landlord, my original erstwhile landlord, sold out the entire property to a third party. Now, in the trial court, we have filed an application for amendment to implead and added that new the vendors, the person who purchased the property. Now, this is the fact situation as on today, my lord. I am only requesting this honorable court because there are two parts of our prayer before the land trial court. One is for restoration, and second is if I am not restored by constructing the house by the landlord, then I may be allowed to construct the house. The land trial court allowed the first part, that restored the possession within a 6 months. Now refused to allow the second part.
Okay, you take a step upon the respondents, we will see. Let notice be served first.
No, their respondent is nowhere, my lord, now.
Then,
That is the whole difficulties with us.
So they are
Then-
doing with a liberty.
No,
therefore,
therefore,
in a report to that effect, we will see.
in such a circumstances, what I play, my lord, subject to the approval of this honorable court, that we may allow to withdraw this, because now a new situation has come up.
and the new persons to be included in the proceeding. So therefore, under such a circumstance, we may allow and also with a liberty to raise this issue before the trial court. But whatever the grievances we have raised before this court, that may be we allowed to raise it again before the trial court under the new circumstances of this case. Otherwise, this proceeding, if continued, because service of notice upon them, because they are not left the place, and reportedly on instruction, my lord, they left the Assam. So it is not difficult to this paper publication, etc. All these rigorous this endeavor we have to take in. So that we limited prayer we have made.
Okay. Heard Mr. Dr. Learned Senior Counsel assisted by Mr. Deka, Learned Counsel for the petitioner. Mr. Dr. submits that some new development have taken place in the meantime after filing of the present proceeding. And under such circumstances, he submits that the petitioner may be permitted to withdraw his petition, granting liberty to raise the issues being raised in this petition before the learned trial court.
Trial court again
Okay.
for
Accordingly,
reconsideration.
taking note of the submission of Mr. Dr. Learned Counsel for the petitioner,
And if we made a prayer,
Is
my
allowed
lord,
to-
that then matter may be considered by the court.
allowed to withdraw this petition, granting liberty to raise the issues that have been raised before this court in this petition before the learned trial court. And in the event of the issues being raised before the learned trial court shall consider the same in accordance with law.
My lord, grateful.
Item 20.
May please your lordship, the office note has not yet updated till now. Therefore, we are not aware whether the service is completed or not.
You want to take phrases that?
Yes,
Heard Miss
D. Goswami on behalf of R. Goswami.
Learned Counsel, appearing on behalf of Mr. R. Goswami, Learned Counsel for the petitioner. Office note dated 28/5/2024 indicates that neither answered notice. No. Yes, neither ID card nor answered notice returned to the section till date. The Learned Counsel for the petitioner submits that the petitioner will take fresh step upon the respondent. Accordingly, it is provided that the be taken within a period of 1 week by speed post and also by usual process. List of the points.
21.
None appears for the petitioner on call. List the matter after 2 weeks. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
22 and 23.
Please, the last occasion, my lord, petitioner took time, my lord, to file the objection, my lord, regarding, my lord, IA 3495, my lord.
Are they present today?
No, my lord. No, I'm not seen them today.
After some time?
All lordship may fix it day after tomorrow, my lord. If lordship,
It is possible, but they may turn up, wait for some time,
after some time, my lord.
after some.
24.
Please, your lordship. Lordship, on the date of the respondent number 6, these 3 IA were filed. And IA number 3518 is the delay condemnation application. There are 3 IA.
Which is the IA for delay condemnation?
3518. Lord, maybe please to peruse our para 10. At page number 5.
The sub is completed.
Otherwise, notice is served. We have taken steps, but from the office note, we came to know that respondent number 6 died. And on 23/9/2024, we came to know. Thereafter, we collect the name and suit is of the year of 2019. And respondent number 6, he was a defendant there and died on 2/8/2021.
No, in this delay condemnation petition, whether notice was served. One and two served.
Hmm?
Notice upon a respondent number 1 and 2 served.
Yes.
In respect of the 2 and 4 and 5 are yet to be served. Hmm? Whether the other side appeared before the court.
None appeared, my lord. In the main CRP also, they have not appeared. Because this respondent number 1, 2, 3, and 4, they are included in an implement application filed by them. And against that order, we have come up. That is, my lord, order dated 16/3/24. Passed in Mize case 336/2020. Arising out of title suit 111 of 2019. In the cause list also, names of any advocate is not shown there. In the cause list also,
No, you tell me, is it not necessary to issue notice in this delay condemnation petition to the opposite parties?
yes, my lord, lordship may pass order, we will take steps.
Because this order dated 24/9/2025 is not clear.
Yes, not clear. There is no clear cut direction there.
Heard Mr. B. Bora, learned counsel for the petitioner. No, for the applicant. This interlocutory application under section 5 of the Limitation Act is preferred by the applicant for condemnation of delay of 820 days in filing petition for setting aside the abatement on the date of respondent number 6. Let notice be issued to the opposite party. Returnable in 4 weeks that be taken by registered post. No, sorry, speed post and also by usual process within a week from today. List after 4 weeks. So in respect of other petition, other application, after condemning this delay.
Yes,
will
then
consider.
it will be taken up. Obliged.
May it please your lordship, this petition has been preferred. And service has been already completed.
Completed.
Yes, ma'am.
So we'll list the matter for hearing then.
We'll be filing a regular affidavit, madam.
You can file in the meantime. Heard Mr. N. Hock, learned counsel for the petitioner, and Mr.
TH for madam.
learned counsel for the respondent. Mr. Hock submits that in this matter, service has already been completed and the matter may be listed for hearing. The learned counsel for the respondent submits that he may be granted some time to file affidavit. To file objection petition, pair allowed, recessal list the matter on for hearing. Sorted.
Okay. 26.
May plead also. Earlier matter intent may kindly be continued.
Okay, interim order first start and self-contained.
What is their transfer application? Notice was issued. I think they have entered appearance.
If for the response. Find that.
You have filed your affidavit.
No, Your Honor, I have to file.
Okay.
We need some time.
Heard, Mr.
F for it,
Learned counsel for the petitioner and Miss
And wait.
learned counsel for the respondent. The learned counsel for the respondent, some instance, you will file objection petition. And praise for granting some time, they are allowed, recessal is the matter. After 2 weeks.
Okay.
in the-
Interim order passed.
After 2 weeks, in the column of admission here. No, sorry, it has already been, for hearing. For hearing, in the meantime, the respondent may file objection petition.
Interim order passed. Sir.
Interim order pass earlier self-contained.
20 square.
My lord, may kindly fix it for admission.
Admission. Heard, Miss,
K. Sharma on behalf of
Learned
Mr.
counsel.
Jain Sahib.
appearing on behalf of
Mr. Jain Sahib.
learned counsel for the petitioner and Mr. D. Chakraborty, learned counsel for the respondent. Since service in this matter has been completed, recessal less the matter for admission hearing.
Interim order, Your Lordship.
When after 2 weeks?
My lord, a date maybe, then they are having.
Okay.
Up to 2 weeks. On
Fix it.
15th March.
30th March.
Public notice.
Interim.
Interim order pass earlier self-contained.
Item 28.
My lord, due to inadvertent mistakes, steps could not be taken. So we will take the step by tomorrow. itself.
Heard, Miss
A. Roy.
A.
A. Roy.
Learned counsel for the appellant. Mr. Roy submits that due to inadvertence, she could not take step upon the respondent, and she will be taking step by tomorrow upon the respondents. Accordingly, it is provided that step be taken by speed post and also by usual process within 2 working days from today. List the matter after 4 weeks.
Much good.
Item 29.
Item B only came to know about any of this. After they have submitted the order before the trial sitting, and they have not served copy to us.
No, we have taken steps. It was not delivered. That is a wrong submission. We have taken steps. It was not delivered. We have also informed them through court also that the case is filed.
We have.
We'll provide copy. That's
That's
fine.
fine.
We will.
Furnish a copy to him.
Yes, we'll furnish a copy.
Heard, Mr. Faraday, learned counsel for the petitioner, and Mr.
As by the.
S. Upadhyay, learned counsel for the respondent. Mr. Upadhyay submits that he has not been provided with a copy of this petition. Mr. Faraday, learned counsel for the petitioner, undertakes to furnish a copy of the petition to Mr. Upadhyay during the course of the day. Recessal is the matter for admission hearing after 1 week or 2 weeks.
Okay.
1 week or 2 weeks?
2 weeks.
2 weeks.
Okay.
Is there any interim order?
Yes, interim order is.
Interim order for earlier self-contained.
Much of.
Item 30.
May I please, Your Lord?
Yes.
My lord, the respondent has entered appearance, my lord. The service is complete, so matter may kindly be fixed for admission hearing.
Admission. Heard, Mr.
A. Ali, my lord.
A. Ali, learned counsel for the petitioner, and Mr.
Do you think?
Learned counsel for the respondent. Mr. Ali submits that service in this matter has been completed and the same may be fixed for admission hearing.
My lord.
They are allowed to recessal the matter after 2 weeks or 1 week.
My lord, I have the instruction that senior SC Sharma has instructed to be listed it on 23/3 if possible. 23/3,
23rd of March.
my lord. Interim order may kindly
Interim
be
order
copied.
pass earlier cell company.
I'm obliged, my lord.
Items 31 and 32. 39.
May I please? In this case, my lord, service in respect of respondent number 4, service in respect of respondent number 4 is neither stated that neither ID card nor the notice answer notice.
Respondent number 4.
Respondent. So, my
You
lord,
want to
letter
take faces that
or may be placed before the my lord Lodgement, my lord, because they will verify from the postal tracking. Whether it is
lodged in
service.
my court.
Yes, yes.
Heard Mr. Purkaiso, learned counsel for the petitioner, and Mr. Sharma for respondent number,
Secondary.
respondents in secondary education department. Mr. Purkaiso submits that those steps taken upon respondent number 4, neither service report nor ID card received by the section till date, and as such, the matter may be directed to be listed before the laws in my court to ascertain service of notice by tracking the postal
Track report.
track report. Accordingly, it is provided that recessal is the matter before the laws in my court to ascertain service of notice upon the respondent number 4. In respect of other respondents completed service,
Comment in there. My lord, date may be given after 2 weeks, my lord.
after 2 weeks.
My
After
lord,
2 weeks.
So you think we will receive our instruction also on that.
first week of March, any date in first week of March.
First week of months.
On 9 March.
9.
Obliged.
Item 33.
Wait, please, Ganesh. But here in this case, we have filed a petition for framing additional issue or amendment of issue number 4.
Should be fine objection in this case. I will do it today itself.
Today itself.
So that there is an interim order in my favor, my lord. But I am also interested that should proceed,
Okay.
my lord. My
Heard
lord, my
Mr.
humble submission before your lordship would be pleased to see the impugn order, my lord. That is, it starts from page 54.
Mr. Sheikh,
to 60.
let him file objection. We will hear you.
Objection.
He want to file objection.
My lord, want to file objection. Okay, my lord. A short date may be given because, my lord, suit is installed by your lordship.
But it
My
was
lord,
stated
at
on
my
the pair made
initiative,
by
no
you.
doubt. But I want that the amendment should allowed and it should continue.
Okay. Heard
Because, my
Mr.
lord,
MSA, learned counsel for the
Only amendment is necessary.
and Mr. Fardy for the respondent. Mr. Fardy submits that he may be granted some time to file objection. Here allowed, recessal is the matter after 1 week.
2 weeks. That's on Gulbara, we need some documents.
After 2 weeks. So as to enable him to file objection, pair allowed, recessal is the matter in the column of admission hearing.
My lord, as
Interim
my
order pass earlier shall continue.
as my learned friend appear, my lord.
Yes.
As my learned friend appear, my lord, it will come in the admission column only, my lord.
Already
Date-
ordered.
Date may be fixed, my lord. The date may be fixed. Obliged, lord.
Office note indicates, my lord, the service is complete, my lord, it will come up for admission.
Okay. Heard Mr. Count, learned counsel for the petitioner, Mr. Mukherjee for the respondent. It is submitted at the bar that service in this matter has been completed and it may be listed for admission hearing. Where allowed, recessal list the matter in the column of admission hearing after 1 week or 2 weeks. 1 week. Okay.
Interim order may be.
interim order passed earlier shall continue.
My lord, I am praying on behalf of my landlord P. Chaudhary, my lord. Come today, my lord. He is appearing on behalf of 1 to 7. It's possible, my lord, on 27.
Service completed.
Service is complete.
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 Heard Mr. B. D. Decker, learned counsel for the petitioner. And Mr. Goswami appearing on behalf of Mr.
P. Chaudhary.
P. Chaudhary, learned counsel for the respondent number 1 to 7.
1 to 7.
1 to 7. It is submitted at the bar that service has already been completed and the matter may be listed for admission hearing.
There's an IA for condemnation that probably will come up for all this.
I know.
3078. 3036, I'm sorry.
How many respondents are here, Mr. Decker?
10 response.
10. So Mr. Chaudhary is appearing only for 1 to 7.
Yes,
In
my lord, and
respect
Mr. Jyoti Chetri is appearing for 8, 9, and 10 as per the cause list.
Okay.
P. Upadhyay and Jyoti Chetri, my lord. They're appearing for 8, 9, and 10.
Okay. None appears for the respondent number 8, 9, and 10. 8, 9, and 10. This is at least the matter. This I is for what purpose?
For condemnation of delay in preferring a review, my lord.
Okay. List the matter after when?
27. On 27, but it's supposed to come from Delhi, that's why, my lord. It's possible, my lord.
Mr. Upadhyay, you were in this matter?
8, 9, and 10.
8, 9. Mr. Upadhyay for 8, 9, 10. When?
27, my lord.
27. This is a list this matter on 27.
Obliged.
It was supposed to be listed for hearing. Well, it was listing in the hearing column. Somehow it has been listed in order.
Maybe listed in hearing.
For hearing in the month of March.
This I is for what purpose?
IA is for this stay.
The matter is ready.
Matter is ready.
We'll finally hear both the matter then.
Yes.
Pardon, Lordship.
We'll finally hear the matter.
After 2 weeks, any date may be fixed, my lord.
No, along with this I
Along with this item.
heard Mr. Upadhyay, learned counsel for the applicant. And also heard Mr. Vishwas, learned counsel for the respondent. His application under section 105, read with section 151 of the Code of Civil Procedure is prepared by the applicant for taking additional substantial question of law for effective adjudication of the instant RSA, being RSA number 07 of 2025. Let this petition be heard along with the RSA number 7 of 2025 on suggested that
5th of March or 17th.
5th of March. 5th of March. 17th March.
Deeply obliged.
Item 37.
The hearing column.
May it please your lordship. Lord, this review petition has come up for the first time today. My lord, I am newly entrusted with the brief. So my lord, may I pray, my lord, let this matter come up for final disposal, maybe next week sometime on a hearing day. Already parties are represented, my lord.
My lord, I have read the petition, my lord. Your lordship, directed, my lord, for making necessary amendment in the earlier service order. But they are stated in the petition that as the department has been bifurcated already, that earlier rule is meant for the social work department. Now it becomes social justice empowerment department. So they need a separate rule, independent rule for their department. That is the actual
Separate?
separate rule. They need a separate rule for the employees of the department, new department. Instead of going for amendment of the earlier rule. It is the
Okay. Pardon me, speech of property, learned counsel for the petitioner. And Mr. B. Pukesto, learned counsel for the
three petitioners.
for the opposite party. Opposite party. Mr. Mohanta, you are for the respondent number 9. Respondent number 9. All the parties are before this court.
All are presented.
Mr. Gupta for respondent number 4 and 5. 4 and 5.
Emergency is there, my lord, because the entire process is for promotion is stopped.
4 and 5. This application under chapter 10 of the Gauhati High Court Rule 2015, read with section 140 and order 47 rule 1 of the Code of Civil Procedure
APS, yes.
is preferred
APS, yes. 9.
for review of the judgment and order dated 15/7/2025 passed in WPC number 4850 of 2022. Whereby the respondent authorities are directed to take necessary steps for amendment of the order of 1994 as amended in the year 2013 as per the mandate of the circular dated 11/1/2012 issued by the RCI. To the extent that the same being repugnant to the central legislation, that is Rehabilitation Council of India Act 1992, the Right of Persons with Disabilities Act 2016, and also to consider the case of the petitioner for being promoted to the aforementioned vacant post of vice principal, staff principal in the special schools, subject, however, to fulfillment of all requisite criteria adhering to the guidelines issued by the RCI. Let notice be issued to the respondent, returnable on, when can it be fixed?
2 weeks.
After?
2 weeks, madam.
After 2 weeks. After 2 weeks. However, no formal notice is required to be issued since all the parties entered appearance and received notice. However, extra requisite copy of the petition will be furnished to them during the course of the day. Let's the matter after 2 weeks. You file caveat.
Caveat.
Caveat is filed.
Yes,
Caveat or be hard caveat. Yes.
39.
May I please your lordship? We have filed an IA for condemnation of delay of 75 days.
Heard, miss?
As-parte, appearing on behalf of
Yes,
Mr.
Upaithe,
C.C.
learned counsel appearing on behalf of
Mr. C.C. Dotto, senior counsel.
Mr. S. Dotto, learned senior counsel for the applicant. This application under section 5 of the Limitation Act is preferred by the applicant for condemnation of delay of 493 days in filing second appeal against the final order dated 19/12/2024 passed by the learned additional district judge Dibrugarh in Mizje case number 35 of 2023, by which the application filed by the petitioner under section 5 of the Limitation Act 1963 for seeking condemnation of delay of 75 days in filing the appeal against judgment and decree dated 14/3/2023 passed by the Court of Learned Civil Judge Dibrugarh in titles of number 7 T of 2019 was rejected. Issue notice to the respondent opposite parties, returnable in 4 weeks. Step be taken by registered on a speed post and also by usual process. Okay, now we come to the list after 4 weeks.
First of all,
Okay. We'll resume after 5 minutes.
My lordship.
Yes.
My lord, the present petitioner was appointed on 15/7/2004, page 26 of the writ petition, as the assistant teacher at Uttar Ghunimari LP School. She was serving all along till today. She is serving since the year 2004, and her name was not sent by DLC. Her name was sent by DLC to the SLC. Thus, SLC said that the 2011 Act has been struck down. On that ground, my case was not considered. Now, your lordship, if kindly see the provision laid down in section 4 of the 2011 Act. Kindly see that Act.
Mr. Mahmood, the case is listed
Yes.
for today for instruction.
Yes, madam. They have filed affidavit, but in affidavit they have said that as the persons who filed the writ petition before the Honorable High Court, whether those petitioners have been appointed after the order of the High Court or not, but they have said that they belong to secondary education department and our present case is elementary department. In that view, but we have on our own volition, we have collected the appointment letter of one such person who was the petitioner in WPC number is 64. That is WPC number 3499 2014, and the order has been passed in that case. Kindly see operative portion, page 68. Upon this writ petition was filed by Shailendra Nath Sharma, page 64. And this is the appointment letter of Shailendra Nath Sharma we have collected. Regarding other writ petitions, petitioner, we could not collect, but because we have a little access to the records. However, somehow we have collected this. So it is emboldens our case. Now kindly see the order passed in that case, page 68. Para 14 may kindly be seen.
Yes.
Para 14. In view of the above, as the service of the petitioner is to provincialize under section 4(1) of the Act of 2011, the court is of the view that there is no requirement of any further administrative order by the department to provincialize his service, and all that is required is to recognize that his service already stood provincialized under section 4(1) of the Act of 2011 in the facts and circumstances of the case. Accordingly, direction was issued, and this order was passed on 22/1/2019. Kindly see page 65. 22/1/2019, this order was passed. Much later than struck down of 2011 Act, because section 4 of the Act is very much clear, my lord. Now, section 4, what does it say?
Okay,
Kindly see page.
Mr. Mahmood, in this matter, This notice has not yet been issued. So let notice be issued today. We will hear the matter. They have already filed the affidavit. You are for the elementary division.
Right.
Okay. Oh. Heard Mr. Mahmood learned. You do one thing. This order, you file it by
Additional
an additional affidavit.
Yes. My lord, may kindly forward me.
Sir, that
Since
is-
2004, I am
No.
out of
Heard Mr.
any
Mahmood
money,
learned counsel
any
for the
benefit.
petitioner and Mr. Talukdar for the SK Talukdar, learned standing counsel for the respondent in elementary education department. It appears that in this matter, notice has not yet been issued. Accordingly, it is provided that notice be issued to the respondents. Returnable on suggested date convenient to both the parties.
That will be on 9th of March.
9th of March. 9th of March. However, no formal notice is required to be issued since Mr. Talukdar entered appearance for all the respondents and received notice.
9th of March.
It appears that Mr. Talukdar has already filed affidavit in opposition on behalf of the respondents, state respondents. In view of above, raises a list the matter for admission on 10th of March.
My lord, may I submit this? Oh, it is already parted, so it is already parted.
Okay.
But
So
only one aspect of the matter. Perhaps the respondent level, who is the headmaster of the school, is not represented. So whether or not one of these presence would be deemed necessary, my lord, in the.
Yes.
Then is my lord in essence.
Headmaster?
may cost him upon him justice service, my lord. If necessary,
Then it
actually,
would not be for admission hearing.
actually, order would be passed by the government because everything is with government. Government has
Then
not.
you have to strike out his name.
All the proposals are from the school, my lord.
No,
And whether,
proposal.
my lord, he is my lord, not a necessary party, then your lordship will decide.
No, that is corrected by DO. DO said that due to bona fide mistake, the name of the present petitioner was not sent.
So these are disputed question of facts, his presence would.
No, how disputed? Because he has admitted. DO has admitted. Page 37 can be seen.
No, now you tell me
Now
whether
there is
you
no
want to serve notice upon respondent number 7 or not.
Expect. Justice service will do it. My lord, kindly allow justice service. As I am a teacher of that school, so I may serve it any time before 9 to may serve.
Notice. Since Mr. Talukdar entered appearance for respondent number 1 to 6,
Yes.
no formal notice is required to be issued. However, extra requisite copy of the petition will be furnished to him during the course of the day. Step upon respondent number 7 be taken.
Forward by my learned senior man.
Okay. Ms. Beaumont for the respondent number 4. Since. No, step upon respondent number 7 be taken by speed post and also by usual process within 2 working days from today. Additionally, justice service is also permitted. After effecting service upon the respondent number 7, the petitioner shall file an affidavit before this court.
This
During the
as
course of-
well as justice service.
Deliberation, Mr. Mahmood has produced before this court one order of appointment dated 5th of February 2025, issued by the Director of Secondary Education. And accordingly, it is provided that Mr. Mahmood shall file an additional affidavit bringing on record the said order. List the matter on 10th of March.
All right.
This is a list the matter as part of.
Highly obliged. As part of. Obliged.
Coming items 22 and 23.
Mr. Soikia, who is for the petitioner?
Sigdal.
So it's Sigdal.
Earlier occasion he appeared, madam, discussing that.
Pardon?
Earlier occasion he appeared, madam, last two occasions.
Well, last time also he appeared.
Last time also appeared, he
Yes.
told that he will file affidavit.
Yes.
What to do? Let it be on next Monday.
Well,
Hmm?
no, we
But
we-
Mr.
we also
Ekis
want that
comment?
matter matter should, from our side also, matter should be disposed of as early as possible. Because,
Yes, all
madam,
right. But in absence of the party.
yes, madam. Monday, madam.
Heard Mr. A.K. Sharma, learned counsel for the applicant. And also heard Mr. Soikia, learned standing counsel for the
I am afraid in item number 23 or contender number, madam, 5.
contender number 5. 5. None appears for rest of the respondent. No, rest of the opposite parties. List the matter on next Monday. In contempt case number 462. Here you are not a party.
No,
in
ma'am.
contempt case. No. 23. 22. Okay. Nice. Foreman for respondent number in item number 22. Yes. None appears for the petitioner on call. How about Mr. Soikia, learned counsel for the contender number 5, present. List the matter after on Monday. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Items for admission, item 9, started.
This is the structural compensation matter that was fixed today. The structural compensation was wrongly paid to another person. As per the last order, Lordship had sought for instructions from the SBI and the private respondent regarding the undertaking taken by them.
That's how sent. Sent. Yes, any information available with us?
I have got the information. I have got it. But they said that they have taken steps for recovery of structure compensation amount of rupees 50 lakh 21,954, which are wrongly received by the sorry, Sri Prophet Bora, son of Rotani Bora. Several hearings took place in this regard. Initially, responsible 8 Prophet Bora agreed to refund the amount which was wrongly received by him. Finally, on 9/7/2024, in the hearing held in the office chamber of the Competent Authority Committee, ATCLA, the respondent number 8, son of Prophet Bora, son of Rotani Bora, expressed his inability to refund the amount wrongly received by him. As the respondent number 8 shows his unwillingness and inability to return back the wrongly received amount, which is fixed against the structure of Prophet Bora, son of Bhakti Bora, the Competent Authority ATC Joha is taking necessary steps to recover the amount under the Bengal Public Demand Recovery Act, and already Bakita proceeding has been initiated. The Competent Authority Land Eviction has a reply from the bank authority to the letter we have sent to the bank. They have not received the reply. And the vital thing under para 3 is very important. Land eviction compensation against land and yacht acquired for respondent of A. Govind Bora, son of Rajani Bora, was amounted to rupees 20 lakh 35,389. There, that
particular amount includes compensation for an amount of is 10 lakhs and that is for land. And Jirat compensation for an amount of is 3 lakhs 8,000, that is Jirat. And additional land compensation of is as per arbitration amount for an amount of rupees 7 lakhs. Total comes to 20 lakhs. You know, against 20 lakhs, Probin Bora, son of Rajani, he has already received 16,45,534, which includes structured compensation for an amount of rupees 50 lakhs 21,954, which is actually payable to the petitioner, plus land compensation for an amount of rupees 10 lakhs 15,000, that is his amount, and Jirat compensation for an amount of rupees 3 lakhs 8,000, that is also his amount. And wherein he received the structured compensation of Sri Probin Bora, son of Bhakti Bora, he is the petitioner. Further, it is pertinent to mention that land compensation of rupees 7 lakhs 11,000, that is awarded by the arbitration award, has been withheld by the authority, which is payable to Probin Bora, son of Robin Bora, the response number 8. This amount has not been released due to failure to refund of the structured compensation of rupees 50 lakhs, which was erroneously given to this. This amount is with the authority now. So the plea taken by the private respondent, respondent number 8, that he is also entitled for some amount for against his landlord. That amount is 20 lakhs only. And against that lot, he has already received 63 lakhs of rupees. He is not entitled for 63 lakhs of rupees.
So now the question is whether any amount is lying in his bank account.
But the bank has not responded. And it is the private respondent not here. He can very well not, let's say before you tell me how much amount is available with him in the bank account. That is his bank account. So the plea.
Yes, Mr. Monta, let this court know about the amount lying in the account.
Right now, I don't have any minor instruction. The minor so far, but the minor land is one of the really things from the report of this one. One of the so far, they are the affidavit instruction. The affidavit was filed, and when the moment to the moment of the time, with that affidavit, this one by commission. Specifically, we have 4. We have for page number 1.
No, Mr. Monto, we are not hearing the matter today.
No, my lord, one thing is there. So part of the claim is there is 62,000. He already received 25 lakhs zeros, 774.8 rupees they have already received.
That is for land.
That is for land and Zirat.
That is for land and Jirat.
That we have stated in our affidavit also.
And then,
Category.
report, it is never showing that any structure or
That's a
is
very-
my land. And that is in the evidence also, the criminal case, that is also being this. And so far, my accountability that I have admitted, it is also by my client.
No, Mr. Monto, we are not going to adjudicate that dispute.
Because this letter was issued on 29/12. Now that was procured, this immediately the complaint was lodged into the Deputy Commissioner, that was received by the Deputy Commissioner as well as by registered post officer, that is being received by. Because I did not feel because at the time that was not available, now it is available. And that Deputy Commissioner was arrested by additional Deputy Commissioner in that case, because lot of frauds were there. Not only him, circle officers, LDC, everywhere by criminal case were there. Some of them approached reporting court for disability bill, and one of the LDC was arrested. They should say these things also, what action they have taken on this my team.
No, in this petition, we are not going to adjudicate those disputes. No.
My lord, they have to, because they filed a title suit for recovery, that is been withdrawn by the petitioner. I have annexed the document. They is against me. That is been withdrawn on filing of my instance settlement. Reference case was sent to the my lord, district judge, that is also withdrawn by the government. So everything with the proof in a 1-to-1, my lord. That cannot be decided in late petition.
Lordship, if Lordship permits, may I make a short submission? May I make a short submission, Lordship? Lordship, regarding the structure, in NHIDCL's affidavit, they have categorically stated that structure was there. And due to difficulties, because of the structure was on top of the highway. So due to difficulties regarding traveling, so accordingly, we had NHIDCL had demolished the structure, and in the affidavit, they have stated that. And regarding Lordship, the title suit, we had withdrawn the title suit because that was not the right forum. We have annexed the order of the title suit in the writ petition as well. No, title suit by us. We have filed the title here, annexed in the writ petition, Lordship. And we are proving, we have only filed, yes, we have only filed the title suit. We have withdrawn the title suit on the ground that it was not the right forum, and the learned trial court below had given us the liberty to approach the honorable High Court with that. So, Lordship, the submission made by my learned senior colleague is not correct, Lordship.
The and the certificate voter comparative. This is the one construction was there, but the ABC in the saying that there is no such certificate of construction or repair. Who will be second? I say categorically that my section was there, and here specifically said that there are some 4 shops are still there. They have enjoyed the land. It is included in this one. They specifically included. 4 shops are still here. They are enjoying the land. But I have been honored included.
So, you are entitled to 50 lakhs, 21,000,
954.
950.
Yes, sir.
So out of one amount that is 7,11,809 rupees are with the ADC now. With the ADC now. That is additional compensation to be paid to the respondent number 8 because already excess payment has been done. That has been withheld.
My lord, for a moment, maybe one thing I want to show up.
The respondent number 8, just the respondent number 8 is entitled for 20 lakhs rupees, 10 lakhs rupees for land compensation, 3 lakhs rupees for this, and 7,11,000 for additional compensation as per the amount. So the first amount of land acquisition compensation of 10 lakhs rupees and zero compensation of 3 lakhs rupees that has been paid to him. Additionally, the amount of 50 lakhs rupees payable to the petitioner has been wrongly given to him. So total 63 lakhs he has received. Therefore, this 7 lakhs which is payable to him has been written. That is with us. So can you release this amount in the favor of the petitioner? This 7 lakhs or 11,809? It is not subject to adjustment. That has to be adjusted. Yes. If Lordship directs, that can be done possibly. Better.
My lord, I don't know my lord, where from this is it. My lord, my land because everything based on the assessment, whatever is done, evidence of the PWD, my lord, is the petitioner. Specifically, secretary certain different. Lordship, I annex the documents, page number 160.
No, okay, we'll see later on. It's not. You bring on this instruction by filing a affidavit. I'll bring it. I'll bring it. This is vital information. Okay. Mr. Sen, on the other day, we have requested you to obtain instruction in respect of the bank account. Any instruction you have received?
We have, my lord, contacted the branch, my lord. Branch said, my lord, unless there is an order.
Okay.
My lord,
Okay. Okay.
They are handicapped.
Okay.
That's why.
Then we'll pass the order.
Fine.
No, you obtain instruction. Let this court know on next day.
Fine.
Heard Mr.
I, Mr. Lord.
Learned Counsel for the petitioner. Then also heard Mr. Nutt. Learned learned senior government advocate for the respondent number. I am for the respondent number.
Court is fully questionable.
Five and six. Mr. Mohanto for respondent number 8. And Mr. Hendrik for respondent number? Respondent number 4. Mr. Borua for respondent number? Pardon? 20. Person to order dated 11/2/2026, Mr. Nath has obtained instruction from the Additional Deputy Commissioner Jorhat and placed the same before this court. We have gone through the same, and Mr. Nath is directed to bring on record the instruction he has received, written instruction he has received from the ADC by filing an additional affidavit. Also, the learned, you are not standing counsel.
No,
Panel advocate, panel advocate, Mr. B.K. Sen of the State Bank of India is requested to obtain instruction about the status of bank account number 10392323206665 of the Kotoki Pukuri branch of State Bank of India, and about the amount lying in the aforementioned account, and to apprise this court on next date. A copy of this order be furnished to Mr. Sen during the course of the day. List the matter on. Which one? Oh, you can file. Mr. Mohanto, learned counsel for the respondent number 8, submits that he will also file an additional affidavit, bringing on record. What is this? One of the complaint. One of the complaint lodged by the petitioner with the additional deputy commissioner Jorhat. Fair allowed. List the matter on when? Maybe across. 6th of March. That instruction I will keep that. You take it back. I'll file it. Return.
take extraction only with regard to the amount that is deposited in the account.
No, what is the status of the account and what is the amount lying in the account?
Whether it is already disbursed, withdrawn, etc.
Yes.
I oblige.
Item number 11.
So here respondents are absent.
Absent, my lord.
Oh, they remain absent.
Notice
Notice of serve upon them.
serve upon them, my lord.
Okay.
Well, I'm against, I'm put your lordship against the reversal of judgment, my lord, in this case. Because trial court, it is a suit for eviction of the respondent, my lord, on 2 counts, my lord. Defaulter as well as bona fide requirement. On the both the issue, trial court decided in my favor, my lord. Then say went to the appeal, my lord. Now appellate court reversed the judgment, my lord, of the trial court. Set aside and reverse. So against that, I am before my lord.
Lordship. My lord, the plain lordship will find it page 49 of the petition.
What is the trial court judgment?
My trial court judgment, my lord, it has lordship will find it from page, my lord, 61. Page 61, lordship. Issues, my lord, will find page, my lord, 66 is the issue framed by the trial court. Two and three. Now, is this number three? Now, issue number two, page 68.
Page
68.
68. Yes.
So far, defaulter issue is concerned. Lordship, may I read lordship? PW1 being the attorney holder of the PW1 in his evidence on affidavit stated that the case of the plaintiff by deposing that the plaintiff number one is the owner of the Schedule A property, PW1 has entrusted with the power of attorney by plaintiff number one to construct the house on the suit land, to receive rents, to look after the court cases and all other activities related to the suit land. Plaintiff number two, oblique PW1, as the power of attorney holder is capable of adduce evidence on behalf of the plaintiff number one as he knows the facts and circumstances of the suit, being the son-in-law of the elder brother of the plaintiff and thus a family member. Exhibit Q is the notarized public or a power of attorney. PW2 is the evidence on affidavit deposed. PW2 in his evidence on affidavit deposed that the plaintiff number one is the landlord of the suit premises papers, but is a plaintiff number two. He is actually managing the affairs of the tenancy in practical purpose. PW2 deposed that he is the one of the witnesses to the power of attorney executed by plaintiff number one in favor of plaintiff number two to look after and manage all affairs of the tenancy matter with the defendant, to institute suit and also to depose evidence. In quote, DW2 in his cross-examination deposed that the newly constructed building was being constructed under the supervision of PW2, who used to come regularly to the construction site. As such, PWD1 being the attorney holder had personal knowledge about the suit land and its requirement by plaintiff number one for being a family member of plaintiff number one. Plaintiff number one deposed that PW1 deposed that the defendant has been a defaulter in the paying of the monthly rent since November 2004. In his cross-examination, the PW1 deposed that the default number was a defaulter in 2004. The plaintiff instituted the suit in the year 2016 because of the assurance given by the defendant to vacate the suit land on the demand given though he is a defaulter. In this context, defendant number two deposed in his cross-examination that the suit was instituted against the defendant in 2016, but he is not aware of the fact that whether the defendant has been paying monthly rent in respect of the suit land properly since 2004 in the court. DW1 is evidence has admitted. Malo, that is the important part. DW1 on his admitted to be a tenant under the defendant plaintiff number but denied that he is a defendant. DW1 as his cross-examiner has deposed that he deposited the rent for the first time in the month of December 2001 in the court, and since then is regularly paying the rent in the court since the last 14 years. DW1 further deposed that he is exhibited 16 challan as rent as exhibit number so and so paid in the court along with his
No, no.
evidence on affidavit. And the-
Mr. Mukherjee, before tendering the rent in
Yes,
court,
my lord, that is important. Section
Whether-
51 has to be complied with. he has
whether
admitted.
he has requested whether he has offered the rent.
No,
to
no,
the-
my lord, that is admitted, my lord. Lordship will sign. A lordship will find the next page now. All that Treasury challenge reflected that DW1 has paid the rent in the name of one Mandip Borua. He is not a plaintiff. DW1 further deposed that he has paid the rent in the court without contacting the plaintiff, my lord. So implicitly, my lord, he did not offer the land because there is a specific pleading to that effect, my lord, that yes, he offered the rent to the landlord, he refused it. On the refuse, he, my lord, opposite a rent deposit case and deposit the rent in the court. And not only this, my lord, even in the course of deposit the land, there should be a timely deposit of land as a settled law decided by this honorable court. Here, my lord, the petitioner only tendered 16 challenges, my lord. No, the 2004 to 2006 Ex-parte is, my lord, the defense. But he has exhibited all the challenges, my lord. And if your lordship look into the evidence, my lord will find it, even the rent deposited or be beyond the 15 days, my lord, which is contemplated under section of the Assam Urban Area Loans Contempt. So to that effect also, my lord, he is a defaulter. So this is the finding of the trial court. And the appellate court, my lord, he has taken into consideration some of the issues, which are beyond the pleading, my lord. That is not the pleading of the defendant at all, my lord. First appellate court, in reversing that finding of the trial court, my lord. He has taken to some, my lord, facts which are beyond the pleading. It is not the pleaded case of none of the parties, neither the plaintiff nor the defendant, my lord. And as per the settle, just place one judgment of the apex court, my lord, which will say, well, just one judgment, my lord. Otherwise, all judgments are there, my lord, because section 5A4 has to be complied with, my lord. Before depositing a loan, has to offer the land to the landlord first. On his refusal, then, my lord, he should go to the court. He should file a.
So the trial court has dealt with this issue in issue number?
Issue number 2, my lord.
Issue number 2.
Yes, it is a defaulter.
How the appellate court has dealt with this?
Now, my lord, the appellate court is, lordship will find. The appellate court judgment, my lord, will find at page number, my lord, 84, no? 84. 84, it is the appellate court judgment. My lord, the issue regarding the rent, my lord will find it. Yes, at paragraph 22, my lord. Page is 94, lordship. Page
Where is the finding?
Now, finding, my lord, says plaintiff abatement in plaint is that the defendant is a defaulter since 2004 and on all subsequent days he is an unauthorized occupation of tenanted premises. In the plaint, it is also about that the defendant become defaulter for the month of November 2004 and continuing to be the defaulter. However, it is if you state in a plain day, defendant paid the rent for November 2005 to and 2005 in NJ case number so and so. In this regard, defendant plain. In this regard, defendant player both in the written statement evidence is that it was in the month of November 2004 in the inspiration and conspiracy of the plaintiff number 2 had to deposit the monthly rent before the court. Section 501B of the Assam Urban Areas Land Control Act, land control it will be, provide that a suit proceeding for the eviction of the tenant from the house can be instituted where the tenant has not paid the rent lawfully due to him in respect of the house within a fortnight of falling due. In the instant case, Prince environment keeps nothing to believe that rent for the month of December 2004 and January 2004 was not paid by the defendant. Exhibit dated 10/11/2007, also plaintiff Muhammad Onas made his awareness deposit by defendant in the court, and that is why he directed plaintiff number 2 therein to receive back the money of the ransom deposited. There is no pleading in the plain as to whether the plaintiff number 2 has complied with the direction of the direction made by the executor on the special power of attorney, and thereby made any effort to collect the rent deposited by the defendant. This makes crystal clear that defendant did not make any default in payment of the rent in connection with NG case number so and so. The attorney holder has not been clarified whether he is complied with the direction of there has been deviated from complying with the terms and condition of exhibit co. There is nothing in the plain that the defendant simply deposited rent in the court. Plaintiff plain that the defendant paid the rent for the month of 2004 and 2005 in the court is sufficient to believe the defendant as per law has paid the rent. That is the, but there is nothing finding that, my lord, whether the rent was offered to the landlord first and then, my lord, he deposited it. And he has taken into consideration some of the facts, my lord, which is not a pleaded case of the pleaded case in the written statement.
Which are the facts?
My lord, these are the facts, my lord. The defendant did not make, the attorney holder has not clarified whether this and that. These are not the pleaded case at all of the defendant. If your lordship look into the written statement, there is nothing. And my lord, he went further also, my lord. Now, lordship will say to paragraph 23, authenticity and genuineness of the exhibit co is the power of attorney is doubtful. These are the facts, my lord, beyond the pleading, lordship. There is no abatement made by that.
Which one?
My lord, exhibit paragraph 27, page 97, lordship will find of the appellate court judgment. Trial court has not gone through all these things, my lord. That was not a pleaded case. Defendant also did not plead that. And on the totality of the facts, he has reversed the finding of the trial court, my lord. Whereas there is a evidence, my lord, to the effect that the defendant himself in this cross-examination has, my lord, admitted that no, I have not offered the rent to the landlord first. I have not contacted the landlord first. I go and straightly deposited the rent in the court. And that in the name of the other person, not in the name of the landlord, my lord. And if your lordship look into the exhibits, also will find that even the rent in the courts also not deposited within the time limit which they are supposed to be deposited, my lord. That also then amounts to a defaulter. And I can produce all the judgment, lordship. Now, lordship, one judgment, my lord, just I will place, my lord. Yes, 2018-11 SCC 652 regarding the additional evidence, my lord. Validity, court cannot record any findings on issues which are not part of the pleading. Any findings recorded on an issue beyond the pleading is without jurisdiction, my lord. That is the decision of the apex court, my lord. Here I have, lordship, I have pointed out the paragraph 27, my lord. He has recorded some findings which are not beyond the pleading. Oh, it will not. This is the judgment. And so far, my lord, defaulter point is concerned. Defaulter return. It is burden on the tenant to prove that he is not a default in the payment law. Mandate of the law is that in order to give benefit under section 5, that the provision of section 5(4) of the Act are duly
So
complied.
which paragraph you have relied upon here?
Here, my lord, in that judgment, lordship will find just come. Para 26, my lord. Para 26. In that judgment. There are 26. Is this issue which we are gone into by the two courts and were concurrently decided by them against the respondent. These issues, in our opinion, should have been examined by the court with a view to find as to whether this finding contained a legal error so as to call for any interference in the second appeal. The High Court, however, did not undertake this exercise, finding it is settled principle of law that parties to the suit cannot travel beyond the pleading. So also the court cannot record any finding. And my lord, so far defaulter is considered bona fide. Though bona fide, my lord, I have placed the other 22 1 GLR 53, my lord, page 9, my lord. But I can place all this. Then, my lord. Now, my lord, this is one of 2018 3 GLR 644, my lord. 10, 11, and 14 paragraphs. Lordship will find. Here, my lord, the ratio is this: defendant, petitioner failed to prove that for the depositing rent in the court, they have ever tendered the rent to the landlord. So that is the marks, my lord. And rent which he refused.
No, in this 2021 SSC online Gauhati 2723.
Yes.
Which are the paragraph you have relied upon?
My lord, 2000, my lord. Here, paragraph bona fide requirement. This is 14, 15, 16, and 17. This is regarding bona fide requirement.
No. This
Yes,
Abdul
yes,
Noor
my lord.
versus Shaukat Mojid.
Bona fide requirement, yes. Here, my lord, 2021 SCC online to say page para 9, my lord. Para 9. Here, para 9, my lord. Para 9. And my lord, that 2018 3 GLR 644, paragraph 10, 14, and 15. Paragraph 10, 14, and 15, my lord. Look of it.
What is the period within which the rent has to be deposited or rent has to be paid by the tenant?
My lord, as per within 15 days from the following due, my lord.
No, was there any agreement between the parties?
There is no such agreement, my lord, but even then, my lord, the honorable court held that it will pay within the 15 days of the say succeeding month, my lord.
And when the respondent herein paid the same?
Now, my lord will, if your lordship will look into the challenge. Now, my lord, it has been exhibited. Just I will take your lordship to this. What the lordship will find. This is exhibit along with the affidavit, my lord. Exhibit 1 to 16, my lord. I have, my lord, categorically stated in my grounds of appeal, my lord, that my lord will find, if your lordship kindly look into. Page 42, lordship. Page 42, ground number 1, my lord. Page 42, memo of my petition, my lord. I have stated, my lord. That is all evidence by the challenge they have exhibited before the trial court, my lord.
Any other point?
My lord, and so far bona fide requirement is concerned, my lord, that is also been held in our favor by the trial court, but it was, my lord, reversed by the appellate court, my lord, on the grounds, lordship will find that, my lord. Then, my lord, page 44, my lord, ground N. That my lord will find. Page 44, ground number N. Page 44, ground number N. Page 44, ground number N. Bona fide requirement of this judgment last name. 101 of the, my lord, it is the power of a bona fide requirement.
Okay.
And bona fide requirement of the family nowadays, lordship as well, apex code as well, is also the requirement of the, my lord, the. So I'll just place, my lord, one judgment, 1415, this honorable court judgment, my lord. So you'll do. And my lord has also recently, my lord, judgment. My lord, in CRP number 17 of 2025, my lord. That's my lord judgment. That is the almost the analogous case. Trial court decreed the suit in favor of the landlord. Appellate court, my lord, reversed the findings. Against that they made before the lord. My lord has discussed this. This is my lord's judgment. My lord. I've just downloaded it from the High Court website. My lord. That's my lord. Here my lord has discussed almost everything. The year one law appellate court judgment is perverse and erroneous law. And that my lord.
Okay, we'll pass the order.
Lordship. Appellate court judgment should aside and trial court judgment. Obliged. Obliged.
May it please your lordship. I am for the petitioner. Mr. M.J. Kadir is appearing for respondent, lordship. Yes. He was sitting in the
Kadir,
court.
Kadir,
Maybe
I have seen him in the morning.
Yes, lordship. He was sitting in the courtroom. Maybe
After
1:10
2.
So at 2, lordship.
Lordship, meanwhile, actually, nothing, morning I would have been very well. Today, I have a problem. I am on fast. My Satan Puja is there in the evening.
Okay.
So already I thought that morning it would have been better. But morning.
Why don't you mention the matter in the morning to upgrade it?
Actually, because of this problem, traffic problem, I could not come in time.
Yes, suggested it then.
Saturday. Next Saturday.
This Saturday.
This Saturday.
Actually, it is fixed.
Saturday is a working day.
It's fixed.
19th, 20th.
Yes.
For hearing under 41, item 15.
May it please your lordship. In this matter, lordship, we are the defendants. The suit was filed by the plaintiff on an allegation that lordship he
So
purchased.
we will start at 2 p.m.
Lordship. Already out of the same judgment, another regular second appeal already admitted by this court, lordship, against the decreeing of the suit.
Same judgment.
Same judgment. Out of the same judgment, this regular second appeal preferred against the dismissal of the counterclaim, lordship. And judgment was already stayed as they have already instituted title execution case, lordship. So accordingly, executive.
Okay, you produce that order, we'll see.
Lordship, applies. Appeal, another second appeal, that is RSA 1/2026 was already admitted. I have given the order, lordship.
on 19/1/2026. And while admitting the regular second appeal in stay petition, notice was issued. Subsequently, we have received notice from executing court. So we have filed another IA, that is IA civil number 176 of 2026. And in that civil IA lordship, stay was granted on 29/1/2026.
RSA number 1 of 2026 was preferred by whom?
By the same appellant, lordship. In this case, what happened, lordship, respondent is the plaintiff. He filed a suit saying that although registered deed was executed in his favor by his vendor, but in fact the defendants are occupying the suit land, so they may be evicted and recovery of possession may be granted in favor of the plaintiff. In that case, we have filed our counterclaim.
No, no, against the
Same
this
judgment.
is one is for dismissal of the counterclaim.
No, lordship, this is present one is dismissal for the counterclaim.
Earlier one,
Earlier one, decreeing of the suit, lordship.
okay, we will see and pass the order.
Lordship. In this case, what happened, lordship, both the trial court and first appellate court held that the defendant could not prove his purchase as because his sale deed number 1 is the document registered in spite of being a registered document. In fact, instead of 813 DAG number, only 81 was incorporated. So that exhibit A was not considered by both the courts below. And thereafter, lordship,
But there is concurrent finding of fact by the court below.
Yes, lordship. In spite of that, that regular second appeal was admitted. Decreeing of the suit is also concurrent finding, lordship.
Okay, we'll see.
In this case, what happened, lordship, they defendant is praying for, lordship, his adverse possession plea is also taking, as because, lordship, since 1970 we are in possession by three different deeds, lordship. One, lordship, though there is a mistake in wrong quoting of the DAG number, but it is a registered document. And the second one is an unregistered document, but the consideration amount was taken by the vendor. And there.
But the question is against the same judgment and decree, whether two RSI is maintainable by the same party?
Yes, lordship, as because my counterclaim is dismissed by the first appellate court as well as by the learned trial court. Counterclaim is itself a suit, lordship. So there are two findings in the suit as well as in the counterclaim. So if we do not challenge the finding of the learned first appellate court or trial court by filing a regular second appeal, then, lordship, my counterclaim will remain unchallenged, lordship. And though the defendant has preferred only title appeal, this is a common judgment. By the common judgment, suit was decreed and title counterclaim was dismissed. There are separate issues formulated by trial court and both the courts decided the issues in respect to suit and in respect to the counterclaim also.
Okay.
And
May it please your lordship. Lordship, I just come to know that the Sonitpur Judiciary Lordship, today court is closed due to alia iligam, lordship. They are observing alia iligam. And lordship, the execution matter is on 20th February for copy of order, lordship, as we have informed the executing court about the CRP, lordship. And lordship had earlier mentioned the periamal case law, lordship. But lordship, periamal case law consists of two words that is subject to. Lordship, if there is a proper justification or sufficient cause, lordship, then executing court can wait. And lordship, the judgment and decree passed in the money suit lordship, that is a ex-parte judgment and decree lordship.
No. The question is whether ex-parte judgment and decree
Yes,
are
lordship.
not executable.
No lordship.
Then
But lordship, the petitioner may also
you
receive
fail to
the
contest the
proportionate
case
decree.
before the trial court,
But lordship,
even after receipt of notice. Therefore, the trial court proceeded ex parte against you. Okay, here let notice go. But
Yes,
there
lordship,
shall not be any stay.
yes, lordship, notice may be issued and lordship, this order dated 3/11/2025, which is passed in petition number 490 lordship. That order may be stayed lordship.
No.
Lordship, if civil nazir attached the property of the petitioner, then lordship, our
Even after attachment of the properties, there is a remedy.
yes, lordship. In
You
that
can avail the same.
2025 order, lordship.
There shall not be any stay.
Lordship, in phase, last phase, lordship. The nazir is directed to attach the movable properties of the judgment debtor as described in the schedule.
Let them execute the decree, we will see. But we will not stay the execution proceeding and also the order.
Then lordship, status quo may be given, lordship.
No, sorry.
Lordship, our
Then this would amount to staying the decree, and for which you have to pay the security.
yes,
You
lordship.
pay the security.
No,
We'll see
lordship,
that.
it has not directed
Hmm.
to us to pay the security, lordship. But we have given the ad valorem, lordship.
Heard. Miss, your name, please.
J. Bezborwa.
J. Bezbora, learned counsel for the petitioner in this petition under Article 227 of the Constitution of India. Read with Section 115 and read with Section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 3/11/2025.
Lordship, lordship, and also one thing, lordship. Lordship, Supreme Court held that money suit may be adjudicated on merit, lordship. And if ex-parte decree or judgment is passed in a money suit, then delay is, lordship, immaterial, lordship. Delay may be condoned, but lordship, learned appellate court is not condoning the delay till
That
today,
you have
lordship.
not challenged that order.
Yes, no, lordship.
Then
But lordship, this court can interfere.
no,
lordship.
no. Here only we examine the legality and propriety of the order impugned before this court. This is not a 226 petition. Passed in money execution case number 6 of 2024 by the learned executing court, arising out of a judgment and decree dated 28/8/2024. Judgment dated 28/8/2024 and the decree dated 7/9/2024. Passed in money suit number 13 of 2023. Where is the petition by the learned civil judge, senior division, Sonitpur at Tajpur? Where is the petition and the documents placed on record? And also where is the impugned order dated 3/11/2025? Let notice be issued to the respondent, returnable in 2 weeks. Effect service of notice by Dismissal.
Okay, lordship.
Returnable in 2 weeks. Step by speed post and also by usual process within a period of 2 working days from today. Additionally, justice service is also permitted. After effecting service by Dismissal, the petitioner shall file an affidavit to that effect before this court. List the matter on fixed date. 10th of March.
10th of March.
May it please your lordship. In this case, lordship, petitioners are plaintiff, lordship. Their second suit was stayed by the impugned order. Challenging that order, this revision petition has been filed.
Second suit was?
Stayed by section 10 of, under section 10, lordship. In this case, what happened, lordship? The petitioners earlier filed a suit for specific performance of contract against one Mosammat Nekbul Nessa Borbuya. That suit was decreed, and thereafter they filed execution petition, and she agreed to execute the sale deed. Accordingly, she executed the sale deed, but later on she denied for registration of the sale deed. At that relevant point of time, lordship, the legal heirs of say Nekbul Nessa Borbuya, not legal heirs, maybe they are claiming that they are the owner of the property of Nekbul Nessa Borbuya, tried to sell out the said suit plot of land to some other person. On that relevant point of time, the petitioners filed title suit number 56 of 2022. That is Annexure 1, page 15.
So the trial court has held that
Yes, Lord.
the issues in both the suit are same.
No, Lordship. The from prayer portion, your Lordship will find both the prayers are completely different, and the second suit was filed on the basis of the subsequent
No,
development.
prayer may be different, but this section 10 relates to subject matter of the suit.
No, Lordship. At the base, Lordship, the Landed Trial Court have directed to decide both the suit joint trial, Lordship. That can be done instead of staying the second suit.
If subject matter of both the suit are same, then why should the trial court proceed with hearing both the matter together?
Lordship, for a moment, kindly.
Is there any provision in the CPC?
Lordship, for joint trial, there is a provision. The
Joint trial, there is a provision, but
yes, Landed Supreme Court also, the Honorable Supreme Court also said that if the cause of action and the parties are same, then both the suit can be decided jointly. In the first trial court, first title suit, Lordship, page 21. For a moment, this is the prayer of the plaintiffs in the first suit. That is 56 of 2022. The reliefs are completely different, Lordship.
No. Whether section 10 speaks about the relief.
Lordship, cause of action are different. In section 10, cause of action to be same, Lordship. For a moment, I am reading section 10, Lordship. Stay of suit. No court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties or between parties under whom they or any of them claim litigating under the same title where such suit is pending in the same or any other court, having jurisdiction to grant the relief claimed or in any court beyond the limits of established or continued by the central government and having like jurisdiction or before the Supreme Court.
You see the wording, matter in issue.
Yes. Here the relief is that, Lordship, the defendants may be restrained from selling the suit property to defendant number 7. And in the second suit, Lordship, it is the prayer of the petitioners that during the pendency of the first suit, the defendants already dispossessed them and they have started construction of pakka construction over the suit property. So their prayer is for recovery of suit land, Lordship. So both the reliefs are different, Lordship. In the pendency of the first suit.
My pointed query is whether section 10 states about reliefs being claimed.
Matter in issue directly or substantively in the earlier suit, Lordship. But here, Lordship, issues are completely different. Whether plaintiffs were dispossessed or not, that issue is not applicable in the first suit, Lordship. Because first suit, they were in possession of the suit property. Page 21, the prayer portion of the first suit, for a moment, Lordship. A decree may be passed declaring the right title, interest and confirmation of Asmali possession of the plaintiffs. over the suit land along with their patta lands and also acquisition of their rights over the same by virtue of the decree obtained thereon in title suit number 2/2021. That is the decree they already obtained for specific
And the plaint of other title suit,
lordship.
page number?
Page 36. That is title suit number 27/2024. A decree may be passed for declaration of right, title, interest, and confirmation of possession of the plaintiffs over the suit Schedule 1 lands by amicable family arrangement with the pro forma defendant numbers 9 to 13. And second prayer, your lordship will find a decree for ejectment of the defendant numbers 1 to 8. So this prayer is not available in the first suit. Or any other person or persons from the suit Schedule 2 land by demolishing the structures, houses, and delivery of cash possession to the plaintiffs through the process of the court.
So you tell me, the parties in both the suit are same.
Almost same lordship, but there are
Almost
some other defendants also. In
the schedule land is also same.
lordship, there are also some differences. So adjudication of both the suits are required, lordship. And in the first title suit, the defendant number 1, 2, 3 are same in the second
You
title
say,
suit.
Ms. Sodhuri, you say, if you fail to make any pair in the first suit, now can you institute the third suit? Claiming such
Yes, lordship, that is subsequent event. After filing of the suit, that subsequent event took place.
Okay. Yes, Mr. Kadir, what is your stand?
My humble submission, they will not be prejudiced. Joint trial can be given. Both the parties will.
Definitely, my lord. And one thing, my lord, this Ex-parte should tell, my lord. My parents in the subsequent suit, there are some plaintiffs is, my lord, removed from the second suit. Some defendants added. In this or that way, the second suit is filed, my lord. And it's held that in the first plaintiff, there is.
No, you tell me whether subject matter.
Same,
The
same
matter
subject.
in issue in both the suit are same.
Same melody subject matter, my lord. The honorable trial court also held when the order is there. There that in the it is held there in the first my lord plane in the first suit. It is not specifically mentioned the all the schedule boundary wall or that they have all the subsequent schedule in the plane they have category not specifically mentioned. All these things it was a case of amendment of the plane earlier. I think without going to amendment, they have filed a subsequent suit, my lord. Moreover, my lord, in the subsequent suit, we have filed a WS. The WS is not on record, my lord. Our case should also have been on record, my in this. It is not part of the record.
Copy of the same is with you. No, copy is with you.
At present, I have not. So it may be I may blame on the record.
No, whether in that WS you have taken the plea.
That I have to go through, my lord. Otherwise, my lord, the subject matter is same subject matter. The subsequent suit only there is the some defendants removed, some new included, some plaintiff removed only to just to satisfy the my lord, overcome the section 10 of the CPC, my lord.
So schedule of the land in both the suit are same.
Same, my lord. Same, my lord.
Same, almost same, but not same.
The boundaries may be.
There are some differences, lordship. And in the second plaint, we have mentioned after institution of the first suit, there were some disturbance, lordship, and thereafter they dispossessed her. And thereafter 145 proceeding was also initiated. Those are on record, lordship. We cannot deny the order passed by executive magistrate and revision court, lordship. Those are on record in the second plaint, lordship. Everything was mentioned. Pleadings are there, lordship. These are subsequent events, lordship.
Otherwise, my lord, may allow 1 week time to be on record my WS, my lord. And matter may be posted after 1 week.
clear date is mentioned when they tried to dispossess, when they dispossess, everything is in the record, in the pleading of the second suit.
No, for the purpose of deciding the issue.
Yes.
Whether your WS is necessary here. The question is whether subject matter of both the suit are same or not.
Yes, matter. Subject matter is same matter. Same subject matter.
So whether your WS will change any.
I have not the copy with me, so I may be given some opportunity at least to work to the WS. And after 1 week, it may be fixed whether.
Okay, let it be on next Wednesday then.
No, sir.
Wednesday. Art, Ms. Art Chaudhary, learned counsel for the petitioner. And Mr. Kadir, learned counsel for the respondent. Heard in part. During the course of hearing, Mr. Kadir, learned counsel for the petitioner, respondent, pointed out that in the second suit, the respondent herein has filed a written statement, but the same is not placed on record. And he submits that he may be granted some time to bring on record the said written statement by filing an affidavit. They are allowed, or else shall list the matter on next Wednesday. Yes, part heard.
There is no 2nd of March, because we have to collect from Monday. On 2nd of March, Monday. Public.
Obliged, question.
For hearing under order 41, item 16.
Wait, Your Lordship. Which is an appeal against the concurrent judgments was by the learned Munshi as well as by learned civil judge, division. That entire thing is revolving down a gift deed which is actually just prepared in this, executed in suspicious circumstances. Lordship, and it should have been, Lordship, that while we are challenging that present appellants, the defendants, challenge the genuineness of the deed, gift deed, and its registration, it is forced. The learned courts ought to have compared it with that records lying in the case office of the sub-registrar Gauhati. Just because one attesting witness identified his signature, the learned courts held that it was genuine. A lot of circumstantial situations are there. Now, one Lordship, the father of the one Gopinath Barak had 3 sons. Gopinath Basak has got 3 sons. Eldest one is Ram Gopal, who is the husband of the present appellant. Other 2 are, second one is Balaram, third one is Subhas. They are all living in the same plot of land, which was procured by Gopinath Basak. Now, Lordship, that about Ram Gopal, the present appellant's husband, was allowed to construct a small residential plot in that way, only about 2.90 lesses, 9 lesses. They have been occupying a 2 lesses of land out of that entire land of late Gopinath Basak. And Ram Gopal died, and his wife is, for last more than 30 years, they have been living there. Now, when there some problems had arisen, she had gone to file a mutation case over that 3.9 lesses of land. But she should have got 1/3 being that way. Then in 1998, she came to know from a circle of his lordship that the land has already been mutated in the name of other 2 brothers on the basis of a so-called gift deed registered in the year of 1989, and without informing him. They did not even know it till it was registered, supposed to be registered in 89. They were living in the same campus. The eldest brother or his family did not know that their father already gifted the land to the number 2 and number 3, to second and third son. It's very suspicious here. Then, when we questioned the gift deed, we found that a lot of frauds are there, Lordship. It was prepared on a dolil which was procured in 1986.
And the gift deed was prepared in 1989. It was in 89. There is no reason why, except 4 years prior to the execution of gift deed, the donations were procured. Now, age of the donor, that is the father, was not mentioned there. And for every registration of immoral properties, permission has to be obtained from the competent court. And it is mentioned in the deed which is to be registered. That was not mentioned there. While a question the PW1, the second sentence, he said he accompanied his ailing father. He said he accompanied his ailing father to the registration office. He did not know whether permission is obtained or not. It was entirely a forced deed. What only thing the Lama court should have done was that the very genuineness of the deed, the trenching on challenge, ought to have someone that connect the documents with sub-registrar office and compare it. Just because one of the witnesses said yes, my signature, that was deemed to be now after living for 30, 40 years, more than 30 years, still occupying this land, admittedly, but this about 3 lessons of land. Now she is sought to be evicted on the basis of that. It's a case of to be not to get others want to have thrown out. There is no remedy for that. The substantial questions of law we have mentioned at page 4, Rusty. Page 4. Number 1, Lordship got it. Number 1, I leave it, Lordship. That number 2, the substantial question of law is involved. As to whether the learned first declared court erred in law and committing a manifest illegality in rejecting the objection raised by the appellant, challenging the genuineness and authenticity of the disputed gift deed merely on the ground that one of the attesting witnesses had admitted his signature thereon, without examining and adjudicating upon the other substantive grounds and material irregularities urged by the appellant, going to the root of the validity of the deed. Question number 3, substantive question number 3.
2 is not required.
Lordship.
2 is not required.
Lordship. What?
This substantial question number 2 is not involved here.
It's involved here, Doctor. Because without, when the genuineness of the deed was challenged, the execution process was challenged, that ought to have been, Lordship, examined by calling the record to sub-registrar which is Gauhati. But one is also there, Lordship. That is solved. Ground number 1.
You said this gift deed was challenged.
There is challenge. That is the substance of the entire case. The plaintiffs number 1 and 2, the second and third brother, filed that eviction suit against the appellants with the widow of the eldest brother. That itself, the gift deed was challenged, which we don't know about it. Saying the same campus, father died in 93 and eldest brother died in 96, and widow is the sons living there in 3 lessons of land only, less than 3 lessons. Surprised when they come to know the gift deed was issued. Gift deed was executed in 1989. The father, they were not informed. All this through to the situation.
Gift deed was executed in the year 1989.
89. And that dolil was collected in the year of 1986. It was probably some fisher while, and that eldest brother staying in the same house, same campus. He did not know. When his widow went to get that portion of the land mutated in her name, then the circumstances says that admitted that you have been living there. But mutation has already been granted in the name of second and third brother. On what basis? On what basis they have that your father of the they gifted the land in 89. It was not there, they are not informed. They admitted that he was not informed.
No, is there any requirement to inform all the family members?
Because he's one of the inheritors,
Hmm.
one of the successors.
Hmm.
It ought that shows to the suspicion, Lordship. The circumstances is filled with suspicions. That may not be a solid legal right, but otherwise, that the same family saying, yeah, a father has gifted his property, the same where other brother is also living with his family, gifted his registered, gifted, and without intermarrying his eldest son or eldest son's family.
No, that question is,
That is
there is no requirement in law for informing the family members.
But that aids to my, it supports my suspicion about the genuineness of the deed.
Hmm.
The whole plea taken by the president is that the deed was forced
Hmm.
because the permission number was not written there. The age of the donor, their father, he was about 80 years old at the time, is not mentioned there.
Hmm.
And the only man who was accompanying the father, the second son, he himself says, I do not know whether permission is obtained or not. I do not know. So these all show a very suspicious circumstances. In such a situation, that the Supreme Court has said that if any
No, that's all right. But the question is whether for executing one gift deed, permission is necessary from the authority.
no, that was sole this father, he is acquired the property himself.
Hmm.
Therefore, the case is that no permission is not him. He's self-acquired property.
No,
Yes,
from whom permission is necessary.
Permission.
Yes.
For any registration of any immovable property, permission is necessary.
Whether for gift deed permission is necessary.
It's necessary. No? It's necessary. Some permission is necessary that I'm going to do that.
No,
No
that's all
permission.
right. For sale and this purchase permission is required, all right.
Lord,
There is no doubt about it. But for gift deed,
that is also same transfer property in the name of gift. That is transfer property in the name of other way.
Hmm.
Selling. The question is transfer of immovable property.
Hmm.
Stamp duties and all this.
Hmm.
They procured the dolils in 1996. That means they have somehow other collect dolil and prepared in 99 before the old man dies. Without keeping the whole thing under separation for 10 years.
Dolil was of 1996.
Lordship, the dolil was purchased in 1986.
86.
Lordship.
Okay.
And the deed was registered. Sold has been registered in
89.
1989.
89.
The question is that whole thing is suspicious. Whole registration process is suspicious. In that case, that itself there is something to be very casually it was dealt with.
How the appellate court has dealt with the same?
The appellate court said that one of the attached witnesses, PW3,
Hmm.
he recognized his signature.
PW3 is the son of the executor.
Because he is the attaching witness. He signed that here as one of the witnesses.
He is the son.
No, he is not the son. Second son and third son, they were there. PW3's son. No, the attesting witness, what was he? Attesting witness identified his signature on the deed. And he
No,
identified
as per requirement, only one attesting witness
one
will be
attesting
sufficient.
proof. But when this suspicious circumstances existed,
Hmm.
then that should have been mathematically proved. There is a judgment.
Hmm.
That in case of registration of will, of course. It says that when issue is regarding but the document is challenged on the basis of its genuineness.
Hmm.
Registered document or then
Hmm.
just one, I read one line or two.
Hmm.
As in the case of proof of other documents, it was the case of will.
Hmm.
The Supreme Court observed that as in the case of proof of other documents, so in the case of proof of wills, it would be ideal to expect proof with mathematical certainty. The test is to be applied would be the usual test of satisfaction of a prudent mind in such matters.
No,
Yeah.
in the instant case, one witness has proved the same.
This set is my
Hmm.
signature, that's all.
And
That
the trial court has, appellate court has found the same sufficient.
is sufficient.
Hmm.
But if all these suspicious circumstances existed,
Hmm.
is another case, Lordship, I'll just read a line, not trouble your Lordship,
Hmm.
where the person who prepares the instrument or conducts its execution is himself benefited by its dispositions, then this is a circumstances which ought generally to excite the suspicion of the court and calls on it to be vigilant and jealous in examining the evidence in support of the instrument in favor of which it ought not to be pronounced unless the suspicion is removed and it is judicially satisfied that the paper does express the true will of the deceased. When I raise the suspicion, very strong suspicion, learned courts ought to have clarified that should have come under, I said, the whole registration.
Let us say how the learned trial court has dealt with the suspicious circumstances. This is the 11th paragraph here.
Judgment court, sir. There will be judgment court, huh? 38. Page 38, Lordship, the judgment of the learned trial court.
38.
Lordship.
Okay.
Imperative. The issues, Lordship, in page 5. Whether the gift deed dated one was fraudulent, and we say it is challenged as fraudulent gift deed. Issue number 6. Whether the gift deed dated such and such dated 26/7/89 was fraudulent and illegal, and as such not binding on the counterclaimant. Issue number 6 is decided, Lordship. But the para 13, Lordship, 13 and 14 at page 46. Yeah, judgment deliberation, para 42, we have a line. The plaintiff Balaram Basak, period 1, in his evidence, Lordship, got it probably, in his evidence, as well as in plain stated that the defendant's predecessor Ram Gopal Basak was the eldest son of the late Gopinath Basak, whereas he is the second son, and the plaintiff number 2, Subhas Basak, is the youngest son of late Gopinath Basak. That their mother predeceased their father. Ram Gopal Basak quarreled with their father, left home. That their father tried to bring him back to home, but he did not come. That he settled somewhere in Borpeta permanently, and his family cutting off all his ties with their father. So late Gopinath Basak used to live with the plaintiffs. But the wife herself said, I've been staying here with permission of since the days of when our father-in-law was alive. It's a small portion of land, Lordship, less than 3 lasses of land. Plaintiff's father, Gopinath Basak, voluntarily gifted his land, measuring 1 kata 5 lasses, covered by dag number such and such, village such and such, under Ulubari Moja, with his houses standing thereon, to the plaintiffs by a registered gift deed dated 1989, Exhibit 1, and delivered possession thereon. The plaintiffs also accepted the gift and used to possess the land and houses standing thereon. The petitioner 1 further stated that their father, Gopinath Basak, out of love and affection, voluntarily gifted his aforesaid land and houses standing thereon in favor to him, and plaintiff number 2, that their names have been mutated and recorded in the records of right during the lifetime of their father, Gopinath Basak. That their father, Gopinath Basak, died in 1993 due to old age ailments. The defendant's predecessor, Ram Gopal Basak, did not come to see his ailing father. The Ram Gopal Basak, during his lifetime, did not question at any stage as to giving of the suit land to them by their father. Lordship, that the Ram Gopal Basak, who works as motor mechanic, died in 1996. Whereas, Lordship, that the appellant filed a mediation case in 1998, then only it was informed that the land was already gifted. Whereas she has been staying, occupying the 3 quarters of land, three lessons of land, Lordship, all along. That was not denied.
They're all along occupying, still occupying.
They've been occupying, and now also they are having their own houses there, constructed during their eldest brother. It was allowed by their father. 3 lessons of land they have been occupying, and they're sought to be evicted from that small portion of land. But other 2 brothers, by filing this suit,
In 2003.
they filed the suit only in 2003. But even they've been living since, this is her statement is that they've been living since her marriage somewhere in 1991 or 92, last 30 years. Everything is revolving around the suspicious gift deed, registered, whole registration process was challenged. In that case, learned courts below should have taken it seriously matter. It should have been proved beyond any doubt. That's what the Supreme Court says. When a deed is suspected, it becomes suspicious or challenge the genuineness process here. It should be done, proved beyond doubts. And beyond doubts means simple thing that's called for the court to have research office and compare with it. That's all. Therefore, it's related to that. Therefore, Lordship, humbly submit that this is a case to be issue to be examined by this honorable court for granting relief to this widow. A bigger portion of land she is occupying, Lordship, less than 3 lesses, 2.9 lesses of land. I read one more. It's just a line of Supreme Court judgment. That's not this issue. These are the lines, para 40 of this year. I placed it before Lordship. Para 40 says, in a similar issue, a jurisdictional question will involve a substantial question of law, full stop. A finding of fact arrived at without there being any evidence would also give rise to a substantial question of law. It is partly which was this fact has been arrived at without proper evidence. Proper evidence is when the deed is being challenged, the genuineness of deed.
That's all right. You come to this paragraph number 31 of the observation made by the trial court.
Lordship.
I perused the gift deed marked as Exhibit 1 and did not find any discrepancy in the same.
I perused the gift deed marked as Exhibit 1 and did not find any discrepancy in the same. The defendant's counterclaimant did not dispute the signature of the donor and the donees. The donor was capable of gifting and the donees accepted the deal. Thus, to my mind, the gift is valid documents. Lordship, that when all these anomalies were pointed out, that the NOC was not taken, that was not mentioned, the age of the donor was not mentioned there, and that only son, PW one, accompanying his father, he did not know whether permission was sought for or not, absolutely. And it was also proved that he was an old ailing person. Therefore, all these things that lead to a suspicious circumstance that has to be inquired. Otherwise, and that is not a huge portion of land, it's only 3 lessons of land where.
Where is the written statement filed by you before the trial court?
I beg your lordship.
Where is the written statement filed by you before the trial court?
Page 18.
Page 18, Lordship. Page 18. Para number 1, present suit is not maintainable. 2, plaintiff is not properly verified. 3, Lordship, got it, page 18.
Got it.
The suit is liable to be dismissed for non-joinder of the parties. Apart from these 3 fathers, This donor had one daughter also. She was not made a party here. She's also living there, but she's not a made a party. There is no cause of action. Then the suit is barred by limitation in measures where the same has been filed beyond the time prescribed by Limitation Act. The plaintiff filed a suit against the defendant number 1 and 2, but the defendant number 2, Shintu Basak, was the minor at that time. Filing the suit, as a suit is not maintainable in line with law. The statements made in paragraph 1 of the plaintiff is not fully admitted by partly admitted, as the plaintiff and the husband of defendant number 1 and father of the defendant number 2 are brothers, and the son of late Gopinath Basak. They are all brothers. The statement made in paragraph number 1 in respect of Ram Gopal Basak, that is husband of the present appellant, eldest son of late Gopinath Basak, at the stage of he went away from home by quarreling with his father is totally false and fabricated one. And as such, the said statement is denied strictly, and the plaintiff is put to strict proof thereof. The plaintiff is within his family, plaintiff is with his family, living with his father in the same plot of land of village Sahar Sasan just what in new this para 9. The statements made in paragraph 2 is totally false, and the same is denied by the defendant. The defendant states that the plaintiffs fraudulently, with collusion made with LS gift deed under the registration number such and such, a plot of land measuring 1 kata 5 blesses, covered by dag number such and such at village such and such, and the defendants all along after her marriage, that is somehow taken place in 91 or 92, with her late husband Ram Gopal Basak, have been residing in the said plot of land, and they gave birth to one daughter and one son in the said plot of land. The statements made in paragraph 3, the plaint is not true and false fabricated. Defendant states that Gopinath Basak, father-in-law of defendant, died due to long ailments, and she herself looked after him from morning to night at the time of his ailment till death. It may be mentioned that the Ram Gopal Basak, who also died in 2895, the husband of the defendant, also looked after his father, late Gopinath Basak, as they all family members were residing together in a family. Statements made in paragraph 4 of the plaint is strictly denied, and the same is put to strict proof thereof. The defendant states that LS gift deed was made fraudulently by the plaintiffs with a malafide intention against the plaintiffs, and as such, they never informed to anybody about the LS gift deed. Statements made in paragraph 5 of the plaint is not true and correct, and hence the same is false. The defendant states that the said statements fraudulently made by the plaintiffs for unlawful gain, the plaintiffs due to their forced gift deed, forced lordship, they said alleged, they with collusion with revenue staff, also able to make mutation against the said plot of land without giving any notice to the plaintiffs. Legal sedimentations obtained without giving them any notice. They have been occupying the land immediately, lordship. Here, Gopinath Basak, there are statements made in paragraph 6. Defendant states that, para 13, second para, she has filed a mutation case wherein the circle officer held that she has been residing since long years in the said plot of land, and as the gift deed cannot interfere by the learned circle officer, and he probably English composition is very not proper, and as such, it was advised to take, she was advised to take shelter in the eyes of law in the civil court. The statements made in paragraph 7 of the plaint is not correct and totally false. In the defendant with her family members have been residing in the suit land since long years, as the suit land is an inherited property. The alleged 15, the alleged gift deed is a forced and fabricated one, but a forced gift deed inherited right cannot be overruled. A counterclaim is also filed, Lordship. So I submit, Lordship, in any case, a small portion of the land was admittedly being occupied by her by constructing a small residence, the widow, for last more than 30 years, since the days of that donor, their father. So, and the circumstances leading with regarding the registration of gift is very suspicious. In that case, Lordship, for the end of justice, it may be stated and the gift should be examined whether it is nothing much donated.
No, that's all right. Two of the courts will have already examined the matter and arrived at a finding in her favor.
The same day they said only one attesting witnesses, he had identified signatures in the turning. When a suspicion is raised with regard to the registration process, the Supreme Court says this has to be proved, mathematically proved.
Now, how the appellate court dealt with that issue number 4. It was issue number 4.
Page 68, Lordship. Issue number?
No, issue number 6.
Okay.
6.
Number 6, good, sir. Number 6.
Para 30, 54.
Para 30. Rajab. Whether this is
55. 54. Page 55.
of the
Memos.
what decisions of the year. Para? I read para 31 of judgment at page 87.
Paragraph number
Paragraph 31, Lordship.
31. Page number?
Page 87. Only memo.
Yes.
It is further to be noted that though the written statement mentioned that defendant number 2 was minor at the time of filing the suit, there is no evidence led to this respect. The written statement was filed only by defendant number 1, but in the court's claim was filed by both. In the counter claim was filed by both. The evidence of DW1 and DW2 are conspicuously silent as to the age of the defendant number 2. This is not the issue here, Lordship. At the time of filing the suit, both the written statement and the counter claim have been verified by defendant number 1, and she has sworn the affidavit and declared that she, being the mother of defendant number 2, aware of the facts of the case, as the defendants did not agitate the minority of defendant number 2 at the later part of the case, it is held that the suit is maintainable on that count. This is another.
No, that issue relating to gift deed is dealt with in
Yes, Lordship.
Page number 91. Decision on issue of 6 and 14. Paragraph number 36.
Lordship. Lord, Para 36, Lordship, I'm reading it. Plaintiffs are claiming the right, title, and interest over the suit land on the basis of gift deed executed by their father, late Gopinath Basar. The defendants' counterclaimants are challenging the gift deed as collusive and fraudulent. The plaintiffs adduce evidence of the scribe and independent witnesses to prove the gift deed Exhibit 1 is a registered deed. PW1 evidence proves that his father gifted 1 kata 5 places of land described in Schedule A of the to him, and the plaintiff number 2 as his eldest brother Ram Gopal had quarrel with his father and used to live separately. The recitals of the deed also mentioned that donor was satisfied with the service of his 2 sons, and he was dissatisfied with the eldest son and voluntarily gifted the property to PW2. He is an independent person and known to donor and his family. His testimony further proves the donor has expressed his desire to bequeath the property to his 2 sons who lived with him, as the eldest son used to stay out after some dispute. He was shown the gift deed by the donor after execution. Defense could not belie his testimony. But if he's been thrown out of the EA, how they have been staying there? It's admittedly, the circle officer also admitted that. They've been occupying 3 acres of land, constructing a house there, living there for more than 30 years. That itself shows these statements made are not correct.
Observation is para 39. Observation of the.
No, the finding of the learned appellate court is that defense could not belie his testimony. That is the testimony of PW2, who is an independent witness.
That is because there was a
Further observe that his testimony further proves that the donor had expressed his desire to bequeath the property of his 2 sons who live with him, as the eldest son used to stay out after some dispute.
that itself was because they have been staying that physical their position, their possessing, they're staying. Now eviction case is filed to oust them. That itself shows the statements are not correct. They're physically possessing the land for last so many years. With circle officer also admitted. So these statements that are case was not properly conducted by probably in between. At the vigilance stage is not properly done, but that appellant should not suffer for that, Lordship.
No, again in paragraph number 38, the appellate court has observed PW is the scribe, PW4 is the scribe, and who proved the factum of gift.
Factum of gift.
He too proved the factum of gift.
And he too proved the factum of gift. Testimony PW of PW4 proves that donor was in sound mind and body when he executed the gift. Though the defense tried to prove the donor was not physically sound, DW1 herself admitted during the cross-examination that her father-in-law was healthy, though he was suffering from cough. PW2 is a doctor and the donor is to be his patient, as he had some respiratory problems. But that does not prove that the donor was incapacitated and was not in a condition to move about and think in the right mind. As it is found from the testimony of the witnesses, the donor expired after about 3.5 years of execution of the gift deed. The defense plead that the plaintiff got the deed executed fraudulently and collusively stands disproved for want of proof. As the donor was absolute owner of the property and the parties were governed by Dayabhaga school of Hindu law, there is no bar in gifting away the property by the father in favor of the son, as he has absolute right of disposal. Mere allegation of fraud is not enough. In fact, the plaintiff obtained mutation during lifetime of their father in 1990 exhibit, but no notice was given to them, Lordship. And Exhibit 2, mutation order shows that there was no objection from anyone. How could you object if notice was given, not given to us? It is all done secretly, Lordship. It shows Gopinath Basa consciously gifted their property. That father would give the property to 2 of his sons and very secretly, without giving any portion of the land to the eldest son, is something very fishy. And the fact that they suppressed this for 10 years, and the appellant came to know only when she filed a mutation case.
No. When the necessity will arise, only then she will file the case?
No. Lordship,
Even the lifetime of the father, there is a.
lifetime of the father, they have never raised it, and she has been staying there. They filed that suit only 2003, 2003. Long after the death of their father.
There is one decision of Supreme Court on that point, where it is stated that when the necessity arises, only then the case will be filed.
Now, Lordship, I was presume that same family, they are living
Maybe,
together.
maybe.
And at
Still occupying and no eviction.
still occupying.
No eviction.
What concern here?
No eviction case.
Execution case also has not yet been filed.
You come to the last portion of the paragraph number 39. The trial court has appellate court has recorded a finding
Does this
that
court
the
agrees
court
with the
agrees with
reasoning?
the reasoning and the decision of the learned trial court regarding the issue of validity of the gift and right, title and interest of plaintiff over the suit land.
That's true, Lordship, that appellate court actually adopted the judgment given by London trial court. Case was not properly conducted on behalf of the appellants, defendants at that stage. But nothing will happen, Lordship, that 3 lessons of land she's occupying, if she's not evicted now, it will not happen anything, Lordship. It will not cause any prejudice to the other 2. When a strong suspicion exists.
Another observation made by the appellate court is that the deed is of the year 1989.
Lordship.
And it is more than 30 years old and produced from proper custody. More than 30 years old.
Yes, that the deed was
Gave to us.
executed in
That was produced from proper custody. So a presumption is always available in favor of the favor of the plaintiff.
What a check of justice, Lordship, that widow and her son, Lordship, they are occupying 3 cuthouses, 3 lessons of land only.
65 years old.
They are otherwise, by way of inheritance, they are entitled to 1/3 of the property. They are living on 3 lessons of land.
So you say that appellate court has also dealt with one of the suspicious circumstances you have pointed out.
Lordship.
The defense argued that the stamp paper was purchased 3 years prior to registration of the deed.
Lordship.
And as such, the deed is suspicious. There is nothing to show that the stamp paper became invalid by
that is true,
efflux of time.
Legally,
Further, it does not prove that the deed was collusive. There is nothing to suspect the validity of the gift.
But leads to a suspicion, that's all, Lordship. When a suspicious circumstances, risk cannot be taken. What I trying to urge your Lordship, that there is some suspicions are there in all around. That it was kept secret for last 10 years, they're living in the same family, they were not informed. Then it was purchased in 86 and registered or done in 89. Altogether,
So, according to you, suspicious circumstances that the deed was kept for 20 years.
Lordship, that it was executed in 89 and she was not informed. She came to know in 1999 when she filed a mutation case. Then she was informed by a circle officer that the land is gone for you. It was gifted, right? The other 2 is, and they, without any serving notice. That's why she wanted to file a mutation case because she did not get the notice of the mutation case filed by other 2 brothers and got the land mutated in their name. And no objection certificate, no objection order was also not mentioned.
Mutation was done in the year?
Lordship?
Mutation was done in the year?
It's in 1990, 1990, mutation done. 1990. In the name of the other 2 brothers.
1990,
Lordship.
90.
And that appellant did not know about it. They did not get any notes about it.
And what are the other circumstances you were pointing out?
That's what I point out. It was not, it's always recorded, no objections when it was in the competent
No
authority.
objection.
It was recorded on the deed. That on that basis, the registrar goes for registering the deed. It was not mentioned there.
But that issue was not taken by, not raised by you before any of the court below.
No, it was, that's questions were put to the, yeah, they admitted it. The PW2, the PW1, he said, what was it? Evidence has put it. Have you got that, obtained the no objection certificate? Why have you not mentioned it? He said, I do not know. He admittedly, he accompanies father as he
Who?
says.
PW?
PW1.
PW1.
One hundred. What is that? I just read out a portion of Lordship that
So any other circumstance you have relied upon?
age was not mentioned.
Age
That
of
is
the?
Age of the donor was not mentioned.
The crucial part.
That is a very crucial part, whether he was in this.
Ailing.
He was an ailing man, that is also proved by some other witnesses. Age was not mentioned, suppressed. It cannot happen. Merely because one of the attesting witnesses.
Any other circumstance?
Hello, Susan, period 183 accompanied the donor but did not know whether the donor took the permission. That is period 1, he did not know. He was accompanying the father.
Any other suspicious circumstance?
No, these are the suspicious, Your Lordship.
These are the, okay.
And witness are the is the PW1 or senator. PW1 or senator.
And according to you, which of the suggested substantial question of law involved herein? You
Ground
have
number
suggested as many as 11 substantial question of law.
Lordship.
Which one, according to you, are 11th here?
Number 2 is more important, Lordship.
Number 2.
Lordship.
Okay. And?
Number 3 also.
Hmm.
What's that say? Connected. Number 4, Lordship. Notice the fact that age of the donor was not mentioned or recorded in the said deed, and without examining the original records maintained in the office of the sub-registrar to verify the capacity and age of the donor at the time of execution, they were raising serious doubt. It is 4. Watch. Available in the office of the
Important one.
What more? Casual. 5, Lordship, that first appellate court misdirected itself in by rejecting the appellant's objections without examining the original records available in the office of the sub-registrar. 5, Lordship. 6, in holding the disputed deed to be genuine, legally valid, despite that the first appellate court held the deed valid and genuine, despite the fact that the permission number, no objection certificate, no objection that allegedly granted by the competent authority for the registration of the said deed was neither mentioned nor endorsed on the face of the deed, thereby raising a serious question as to whether the deed was executed in accordance with the law and whether such non-mention of mandatory permissions vitiated the registration proceedings.
No, you tell me, is there any requirement in law to mention the no objection certificate in the gift deed?
Not certificate, no objection order to be said like
Yes.
the competent authority's permission has to be obtained before registering any.
Where it is provided?
No, that is exactly, I do not know, but that connection.
So to be a substantial question of law, there must be some law point involved. in the substantial question of law. What law point is involved with this?
Section 34 of the registration, I just read out what is my
34.
34 also. What else? 34.
Registration Act.
Section 30,
34 also.
34.
Inquiry before registration by the registering officer. Subject to the provisions contained in this part and section 41, 43, sections N89. No document shall be registered under this act unless the persons executing such document or their representatives, assigns, or agents authorized as aforesaid appear before the registering officer within the time allowed. It's all right. Provided that if owing to urgent necessity, that doesn't come in lordship. Appears under section 1, we cited different times, inquire whether satisfy himself the identity of the persons appearing before him and alleging the these are all mechanical lordship. But the rule requires lordship that as per notification circular, that permission that competent authority, that is DC, must be obtained before registering any document regarding.
Can you produce a circular before the court?
Something is there, lordship, that whenever it goes for registering in any document involving transfer of human property,
Now,
the permission has to be obtained from now.
You ascertain it and produce it before this court on next set. We'll fix a short date. We'll see.
Lordship, then.
Because we have to frame substantial question of law.
The other questions are there, I have raised.
No, that is, that's a there.
question, any one question,
That's a there.
any one question will print.
Can you produce it in the next week, Monday, next Monday?
I'll try to procure it, lordship. Some, yes,
We'll keep the matter as part of then.
lordship.
I do.
Heard Mr. R.P. Capital, learned senior counsel assisted by
It
Mr.
will be the next Friday, lordship.
Friday.
It might take time to obtain the document.
Okay.
Next Friday.
Yes,
That-
what is your name?
Yes, to the lordship.
S. Sotodor, assisted by Mr. S. Sotodor, learned counsel for the appellant.
27.
Leaves the matter on next Friday,
Next 27th, lordship. 27th of February.
27,
Lordship.
for further consideration.
That is Friday. Obliged, lordship.
May I please your lordships, by order dated 9th of February, we were allowed to take dusty service. We have taken the dusty service. We have filed the affidavit also, lordship.
When?
On tendering the notice, lordship, he declined to accept that notice, lordship. And that is in
When did you file the affidavit?
lordship. We have filed the affidavit, lordship.
When?
We have filed the affidavit on 13, lordship. Affidavit is in the record, lordship.
On 13.
On 13, we have filed, lordship. 13. Moreover, your lordship, in annexure B, C, and D, that tracking report
Okay.
the notice sent by this court, your lordship, in page number 100, 101 and 102, lordship. In tracking report, it is showing that the item delivered in Maibela, lordship. The notice sent by this court, your lordship, earlier. This tracking report shows that it is delivered, lordship. And as per Dasti service, lordship, we declined to take the notice, lordship.
Okay. Heard Mr. Dasgupta, learned
lordship.
for the appellant. Mr. Dasgupta submits that after effecting service upon the respondent, the affidavit is filed on 16th, 13 or 16? 16. On 16th of February 2026. Perusal of the same indicates that the respondent refused to accept the notice, declined to accept the notice. In view of above, notice deemed to have been served upon the respondent. Mr. Dasgupta further submits that as per postal tracking report, the speed post number ES 0602849228IN dated 22/1/2026 was served to the respondent in his official address at Maibela, residential address at Maibela.
Lordship, delivered on 31st January 26.
And the same was delivered to him on 31st of January 2026. 2026. So
May I please, your lordship?
we'll list the matter after 1 week. We'll see
Lordship,
if in the meantime anyone
they are
entered a
pursuing the
petition.
executing execution case very hard, lordship. It is fixed tomorrow, day after tomorrow, lordship, on 20th.
Day after
This is the
tomorrow.
whole trouble, lordship. They are
No, no.
pressing that execution matter very hard, lordship. I have filed the IA also, lordship, in the matter for staying the execution matter. Further
No,
proceeding on the trial court, lordship.
Mr. Dasgupta, we have to see whether any counsel has filed any ukalatnama or not. You have filed the affidavit yesterday.
Lordship,
You have filed the affidavit the day before yesterday.
lordship.
If in the meantime someone has filed ukalatnama, we'll see.
Lordship, that is there yourself, lordship. But in the executing court,
Maybe
lordship,
we are not yet admitted. We have not yet admitted the appeal.
lordship, I know, lordship. But my appeal will be infructuous, totally infructuous. I am a retired teacher, lordship. I am staying there with my wife and unmarried daughter, lordship. It's a very hard case on my part, lordship.
Maybe. Unless and until we admit the appeal, we cannot say anything.
Lordship,
at this moment.
that's true, lordship. That's true. Huh? Next Tuesday, lordship. This Tuesday. An effective order may be given so that I can send it to them, lordship.
No.
I'll get the
On
order.
that day only we consider your pair.
Lordship.
We'll consider whether we can admit it or not.
Lordship.
List the matter on Tuesday. Next Tuesday.
Tuesday, lordship.
Tuesday. In the meantime, registry shall put up an up-to-date office note as to whether any counsel entered appearance by filing ukalatnama on behalf of the respondent.
Lordship.
24th.
Okay. Blind.
My lord,
My lord, the present respondent lordship, he sold a plot of land of 1 katha out of a total plot of land 1 biga to the present petitioner number 1 lordship in the year 2019 lordship by way of a unregistered sale deed. And subsequently lordship in 2022 he came up with a story that at the time of execution of the sale deed, the present petitioner number 1 promised him to return the plot of land if he fails to develop the plot of land and fails to construct the RCC building lordship. With that, those pleadings lordship, he filed this title suit, which was registered as title suit number 22 of 22 lordship. In the prayer lordship, there is a amongst others at page number 24. There is a prayer for specific performance of the contract lordship. Contract that a verbal promise that is to be alleged to be made by the present petition number 1 lordship. And we appeared lordship, we filed our WS along with our counterclaim lordship. And pro forma defendant number 4 also filed a WS supporting the case of the present petitioner's lordship. And thereafter lordship, in the year 2024, they came up with a new story that no, that was not a sale deed. In fact, it was an agreement, and that is required to be cancelled. We want the khas possession of the plot now. But subsequently, lordship, by an order dated 18/6/2024, that petition was not pressed by the present respondent lordship, plaintiff. But again, in the year 2025, they came up with a fresh petition under order 6, rule 16 and 17 lordship. That petition is at page 7 lordship. And now, lordship, they are trying to insert certain pleadings lordship, which will all total disturb the will change the nature and character of the suit lordship. Initially, their plea was that it was a case of specific performance with regard to the verbal promise. Now they are saying that in fact the sale deed, which he has admitted himself in his plain lordship.
The earlier petition was not pressed.
Not pressed lordship. That was withdrawn. That order is at page 64, annexure 6 lordship. And subsequently, lordship, on 18/6/2024, that was withdrawn. And again, on 1/8/2025, this subsequent application has been filed, lordship, with certain new pleadings and new story, lordship, and which will ultimately change the nature and character of the original suit, lordship. We filed the objection, lordship, but our objection was not considered, and the learned trial court has passed the order allowing the amendment, lordship.
At what stage the suit is pending?
Suit is pending. As per my instruction, issues are not yet framed, lordship.
Not yet framed.
Not yet framed.
So on that count, there is no bar in amendment.
No, there is no bar amendment, lordship, but the amendment.
Your concern is that only
yes,
the nature and
nature and
character of the
character.
suit.
Totally, lordship. Earlier the specific performance. Now he is asking that no, that sale deed was fraudulently executed. I mistakenly put my signature. Now I want the khas possession back, lordship.
How the trial court has dealt with the issue?
Trial court has simply passed an order, lordship, at page 78 onwards, lordship. As trial court has simply recorded that the trial court has the power to, under order 6 rule 16, to remove the parts of a pleading at page 83 down below, lordship. May I read, lordship?
No, entire order is not required to
last part of the order, lordship, page 83, lordship. Thus, order 6 rule 16 empowers a court to remove a parts of a pleading that unnecessary, scandalous, frivolous, and vexatious, or tend to prejudice, embarrass, or delay the fair trial of the suit, or otherwise constitute an abuse of the court's process, and by striking out improper matter. Under order 6, rule 16 may be applied to prevent prejudice and embarrassment on the part of the party, and to ensure that the trial is focused on the real questions of controversy of the suit. In the matter in hand, record reveals that instant suit is pending at the stage of documents and issue. As such, it can be considered the trial of this suit has not commenced yet, and the suit is at its initial stage. It is seen that the amendment has been sought by the petitioner, which is necessary for the purpose of determining real questions in controversy between the parties. Further, the court has come to the conclusion that if amendment is allowed, it is likely to prejudice to the petitioner. Moreover, even if the amendment is allowed, the defendant side would get the opportunity of filing additional written statement, which would prevent the defendant side from being subjected to any prejudices. Admittedly, there is no bar loss, but if the pleadings that are being brought in by the plaintiff, it's tending to
Where is your objection?
objection is at page 71 lawsuit, Annexure 8. And in the objection lawsuit, we have stated everything regarding the filing of the earlier application under Order 6 Rule 17 that was suppressed by the subsequent application.
No, that was withdrawn.
No, sir.
Subsequent filing of the application is not barred in the CPC.
Yes, but that has been suppressed. That's what we have highlighted before the learned trial court lawsuit. And in paragraph 9, 10, we have specifically.
Where you have taken the plea that it will change the nature and character of the suit.
Page paragraph 9 lawsuit. Page 77 lawsuit. 72, sorry. 72. Page paragraph 9 lawsuit. And also paragraph 10, 11 onwards lawsuit.
Now at what stage the case is pending?
Now, on 13/11, this order was passed, lawsuit. We came to know only on 5/1/2026, lawsuit. We were asked to file our additional WS. With on the last date fixed, we took adjournment. Tomorrow is the date fixed for filing our additional WS, lawsuit. And lawsuit knows it very well. Law is well settled, lawsuit. If the necessary character is attempted to be changed, lawsuit, that cannot be allowed, lawsuit. Even the prayer, lawsuit, specific in the earlier suit, it was prayer for a specific performance. Now, has possession and the eviction of the present petition number 1, lawsuit.
Let the other side appear.
Lawsuit,
Notice go at this.
The further proceeding may be said, otherwise will be prejudiced, lawsuit.
How?
Lawsuit, the additional WS, if we do not file the additional WS, lawsuit, then the case may proceed ex-parte, lawsuit. And with this error, lawsuit, there is no.
No, law is well settled that in order to determine the real question of dispute, the parties have to, the court has to allow all amendment. There is a recent ruling of Supreme Court.
Lawsuit, if there is I'm also relying on a recent judgment, lawsuit, which says that if the necessary characters is attempted to be changed.
But where you have mentioned about changing the nature and character of the suit?
Lawsuit, in paragraph 9, lawsuit, paragraph 10, in our objection, lawsuit.
9 only you have stated that a basic fact of the original plea.
Yes, lawsuit. But the thing is that the earlier plea was for the performance, specific performance. Now he is saying that no, the earlier registered deed what in fact was not the sale deed. Now it was fraudulently executed. Now I want cancellation of that. The plaintiff himself is not sure about his case, lawsuit. And this
that will be decided by the trial court, not by the court. We are only examining the correctness of the order by which the trial court has allowed amendment.
Lawsuit, the point by point, lawsuit, if I show, lawsuit. In paragraph 6(1), he is trying to insert at page 66, lawsuit. And paragraph 6(2), lawsuit. And in the prayer also page 67, lawsuit. He wants to deletion of the earlier prayer at paragraph 1(1) and 1(2), lawsuit. Now at paragraph prayer 2, he is adding a decree of specific performance instead of date. He is saying that he is want to be deleted and replaced by the sale deed, which is alleged to be executed by the plaintiff, is declared null and void, lawsuit. In his earlier plain, lawsuit, he himself admitted that I have executed the sale deed, lawsuit. And how it can be null and void, lawsuit. From his own pleadings, lawsuit, in the suit.
Okay, but apparently perusal of the impugned order
Lordship.
Shows that the learned trial court is aware of the legal position.
Legal position, there is no dispute, Lordship. But whether the amendments that are attempted to be brought in, whether that will create sense and
Let
necessity.
the other side appear, we will see.
Lordship,
But
at least
person in order is saying the.
till the next date, Lordship, because otherwise the
No.
present petitioners will be prejudiced, Lordship. Otherwise the case will proceed. There is a possibility of proceeding ex-parte also, Lordship, if we do not
No,
file.
you filed the petition before the trial court. That's one clear case pending.
Lordship may fix a date, Lordship.
Also
Lordship may fix a date, Lordship.
heard Mr. Didas, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read Section 115 of the Code of Civil Procedure, 1908. The petitioner has challenged the order dated 13/11/2025 passed by the learned civil judge Junior Division Udalguri in Mingze case number 50 of 2025, arising out of title suit number 22 of 2022. Notably, by the impugned order dated so the learned trial court has allowed the petition number 1200/2025 filed by the respondent herein under order 7, rule 16 and 17 of the Code of Civil Procedure.
Order 6, Lordship.
Where is the petition and the documents placed on the record? And also where is the impugned order dated 13/11/2025? Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with by speed post and also by usual process within week from today. Additionally, dusty service is also permitted. Will fix after 2 weeks.
Lordship, till returnable date, Lordship. Humbly pray, Lordship.
Dusty service is also permitted after effecting service upon the respondent. The petitioner shall file an affidavit before this court. List after 2 weeks. 6 of March.
Lordship, till the returnable date, I humbly pray, Lordship.
No,
Because
your
tomorrow
prayer
is
is
the
there, that's all right. But apparently the impugned order appears to be not suffers from any infirmity.
But the learned trial court, with all respect, Lordship, has not gone into the factual part, Lordship.
We are not supposed to consider the factual aspect under Article 227. Here only the legality.
Lordship, but there may be an observation that we will be at liberty tomorrow to seek an adjournment before the learned trial.
No. You can file, always liberty is there. You can file any application before the trial court.
I'm a